Just for a week.
I'll write it down. Why should you waste time?
1883.
Yes. Then
Lordship, item number
for a week.
35.
Number?
35.
Yes.
It is in fever. So,
Huh?
okay, it is in fever, Lordship. Kindly,
Care of the learned counsel for the petition. Trust and adjourn for a week. Okay. Yes.
oblige.
May I please? I
What
case council began us today.
Six.
The other side advocate also.
E6.
46.
46.
Care of the learned.
May please, your lordship, except for listing regular bail option tomorrow, lordship.
What?
Motion.
On criminal appeal, criminal
Regular bail. lordship.
regular bail.
Other pair, lordship, item number 17 and 60.
Item number?
17, 17 and 64.
Yes.
List after 2 weeks, lordship.
17 and
64. 64. What is interim, lordship?
64 CD is there, man.
64 of item 64
Supply list, man.
Supply list.
Supply bailing.
after any interim in 64
64 interim, lordship.
interim we cannot adjourn for 6
Lordship, on Friday, lordship.
CD
In 64 CD is there.
it is there,
Friday, lordship.
not Friday, Wednesday. Before Wednesday interim order to continue. And what was the other?
17.
17. You take in the month of after vacation.
Lordship.
After 2 weeks, no, you take.
Scan को भी किसी दिया रहा है.
The purpose will be served after 2 weeks, after vacation. After vacation, after ensuing vacation.
May I please, your lordship?
Yes.
Listing of anticipatory bill, lordship. It was supposed to list on today, lordship, but it was not listed.
Item number?
Not the AB number 1182
Now it was supposed to be
listed on today, lordship. But
today.
it was not. Can it be on tomorrow?
It was fixed.
Fixed.
Very.
Yes, yes.
May I please, your lord?
Item number 20.
24 CD not received.
It did not receive when?
कौन सा नाम? CRPS मतलब no. Next on third मतलब
Next Monday.
third.
Third. Did not receive. Third kori. Yes.
Lordship, I beg to mention item 43, your lordship.
Item 47.
43, your lordship. I have taken the consent
43.
of the others.
For respondent or petitioner? Why you want time?
I have challenged quashment of FIR, your lordship. But today I got the information that
Prayer of the learned counsel.
Lordship.
Yes.
Lordship, in item 47, I have filed one IA, Lordship. I am on behalf of respondent number 2, Lordship. Kindly call for the record, Lordship.
47.
Yes, Lordship.
Okay.
Deeply obliged.
To mention item number 4. There is no order to call for record, my lord, but the record is not come, my lord.
What record is required?
LCR was called one.
Huh?
LCR was called for, my lord.
57 of the supplementary list.
57,
There are some pencil marks, Lordship. May I
supplementary.
supplementary list, Lordship. There are some pencil marks, Lordship. My clerk did not erase it. Lordship, may kindly allow me to erase it by. Obliged,
The
Lordship.
prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on next.
I'm not even praying for adjournment, Lordship. May take it.
We'll pass the
Obliged.
order when you.
Lordship.
Yes.
Deeply obliged.
Well. Yes. But sir, when?
Bohisto, my lord, on 4th.
Fort, CD Fort.
I left.
One application, Lordship. 83 days in custody, Lordship. Rashid not filed yet.
Have the instruction.
CD
days, How did it writing?
On my lord, 4. Oh,
Only
83 days,
83
no?
days. Can you
Sir.
take up tomorrow?
My lord,
Obliged, Lordship.
Just in a motion,
it is panel.
right? Submitted that the petitioner is behind since last 83 days. Sir, Parasar Lanet, additional public prosecutor, submits that he may be granted a day's time to obtain instruction. But search sheet has already been filed. Further submits that he will also have the case diary. That is allowed, please this matter to. How many days?
29 days.
Copper where?
All petty thieves.
We are another case, but when we went to the police station, we are arrested. Madam.
Period of detention, Nesar of
Kamrup Metro.
Kamrup Metro.
No, my lord, I'm sorry, my lord, till now, instruction not received. At 2, my lord.
None appears for the petitioner.
No,
Oh,
he did.
sorry, you are here.
My lord, at 2, my lord, I'll take instruction.
At 2.
I've already.
Assigned page number 10, Lordship.
Who are you?
I am the regional manager, Lordship.
Okay, appear within 10 days.
Obliged, sir.
And we'll see, but there is no
Yes, sir.
experience. After looking into the case, there we will only see. Because
And-
some others were granted anticipatory pay, similar situation, that's why.
Yes, sir.
But don't arrest them this time.
12. 12.
If they have any doubt, and you, mister,
If you come.
don't give explanation of your this illness and all. Appear
Yes, Lordship.
No, 12 problem আছে বলে। 14 June.
14th
Yes, Lordship.
interim, huh? Who are you?
I am the owner of a track, Lordship.
Owner of the truck.
Track, Lordship.
Where
Kindly
have you
come,
stated?
page number 12, Lordship, is the registration certificate.
Where is your statement?
I have it in my petition, Lordship. Para number, Lordship.
Huh?
3, Lordship. Number 4. Extra owner, Lordship.
City interim, 10 days.
Published.
Office to मतलब 12.
12.
12.
Published, lordship, published.
Who are you?
Go report.
I am one of the employee, lordship.
One of the employee. लिखा है ना तो? Is that child labor were engaged pre-clean owned by one who is owner? Huh?
1, 2, 3, मतलब Tahir. Subur,
One of the Tahir Ali, Abdul Subur
Rafiqul Islam. lordship.
and Rafiqul Islam.
Okay, na?
Who are you? You are the ambassador. Rafiqul Islam. And one child died due to negligence of the aforesaid. The petitioner claims to be a co-worker slash employee under the F and under the aforesaid 3 persons. First of all, accordingly, considering the nature of allegation and also considering that yes, within 10 days appear.
On 18 June मतलब.
Financial transaction. Doubtful. CD interim in 10 days.
Time protection may be granted.
Already
Yes,
granted.
purpose. Returning.
Deep.
Sadgaon.
In 10 days appear.
14.
Yes, where is the FIR?
I am working as Assistant General Manager, Assam Electricity Grid Corporation Limited.
CD interim. Husband's wife, this phone, husband is not picking up phones, is not it?
Actually, my lordship, she is separated from in the year
Yes, next
2021.
case.
Divorce is filing.
14. 14.
Your lordship.
Yes.
Lordship,
Item number?
lordship. Lordship, at page 11 is the intimation letter where I have been called for recording my statement in the concerned. Lordship, I have a genuine apprehension in this limited protection, lordship, till tomorrow.
Where
Lordship.
is the complaint?
Page 11, lordship. Complaint, we don't. That is my case, lordship. I don't know the nature of the complaint. I have absolutely no idea why I am being called for. And lordship, from page number 12
When is
onwards.
the date of appearance?
Complaint submitted by
Tomorrow,
wife.
Which police station?
Complaint submitted by wife.
Pan Bazar police station, lordship. Pan Bazar.
Mr.
A6.
May not be registered only because if registered number has been
Number
given.
has to be given. Just have the instruction for
Hello.
whether any custodial interrogation is necessary and what is the complaint. At 2?
At 2.
At 2.
Lordship.
He might not have any apprehension.
9 to
Please, your lordship. The lordship is challenging the complaint against my
Why should you entertain?
your lordship cause of action arose here in Jorhat. Loan was taken at Jorhat. Default was made at Jorhat.
To go to the Kolkata High Court and say that this is not
That's why
mentioned.
my lord 226(2) has been my lord incorporated.
Doubtful.
Because of the unnecessary harassment, my lord, this complaint was lodged.
No,
at the-
see, there may not be all things may be here. A magistrate has taken cognizance wrongly, according to you, ignoring such facts at Kolkata.
My lord.
Can Kolkata High Court say that no, it is not not your jurisdiction. Everything is done here because the Kolkata High Court is having jurisdiction over the magistrate.
Same question came up before this honorable court, my lord.
Huh.
And the judge of this honorable court had
Any decision that
Yes,
was
ma'am.
that
That
was a
is-
notice and notice
no,
was
my lord, decision
notice was issued and
passed
then
by my
there was a
honorable,
stay.
my lord, honorable Justice Ujjwal Bhuiyan, your lordship. Complaint was quashed. Stream was there, but here complaint was quashed at Agra, your lordship. Referring to 22 and all. There are 8, your lordship.
What is your cause of action for this criminal petition?
So loan was taken at
No. What is the cause of action for your criminal petition? You are challenging what?
challenging complaint as well as the cognizance taken
So that cause of action arose in Kolkata.
part because my lord the part
No, there
Complaint
are
was
two
passed-
distinct things. Cause of action so far relating to the complaint. For filing a complaint, maybe in this case Negotiable Instrument Act, arose at Guwahati. Okay? No doubt about that. According to, let us accept that. This is a cause of action to file a complaint. Now a complaint has been filed in Kolkata where cognizance has been taken. So you are aggrieved that this could not have been taken. And that cause of action arose within the jurisdiction of Kolkata High Court, and Kolkata High Court is having superintendence over a
227.
magistrate. This court is not having superintendence over the magistrate.
So
And why should we pass a futile order?
here the
Where
complaint,
is their authority to quash a
I'll-
complaint in Kolkata which has been filed?
the ingredients in complaint, it is in respect
Can
of
we look into that at this stage?
yes, your lordship. This honorable court entertained another petition also, my lord. Notice has been issued. And here also, my lord, this honorable court quashed the proceeding initiated at Ali.
Show us. I am not convinced. And we want Supreme Court judgment. Cause of action according to us, two parts. One
Lord,
cause
if
of
the
action.
fraction, my lord, your lordship may
What will we do?
Supreme Court decision, your lordship will see regarding cause of action.
Cause of action we understand. Maybe
Even
there may be part cause
fraction
of,
of cause of action if arose, my lord, this honorable court has jurisdiction to entertain. That's why
so that is a jurisdiction under what?
226 to your lordship.
226. And what is this petition?
226, your lordship.
226. Now tell us, can by offer 226 an order of magistrate be challenged?
My lord, in fact, yes, in Bhajan Lal, my lord, your lordship,
No, Bhajan Lal, subsequently it was clarified whether 226 shall be maintainable by Supreme Court.
that decision, my lord, Radheshyam decision, your lordship. Radheshyam says in respect of civil court. Bhajan Lal says, my lord, because criminal court and civil court are two different things, your lordship. Bhajan Lal says complaint and criminal proceedings.
Okay, agreed to that extent. Now tell us, what is the cause of action for this?
My lord, allegation is in
Where is that
respect.
recent judgment? Tell us.
I have Kusum Ignot and my lord Naveen Chandran I have given 226 to, and Bhajan Lal once your lordship may kindly see, it says about 226 and 482. Because in Calcutta 482, there is no need to file 226. Why Bhajan Lal 226 has been given? Because of such type of complaint, FIR. That's why in Bhajan Lal para 102, my lord, two terminology has been used, FIR/complaint. Flag mark, your lordship will see.
Okay, what was the case in Kusum in Goch? What was the challenge in Kusum Ingots?
FIR.
Let us see the relevant.
Para 9 and 10, your lordship may kindly see. Para 9, your lordship may kindly first see. May I read, your lordship?
Yes.
Although in view of section 141 of the Code of Civil Procedure, the provisions thereof would not apply to writ proceeding. The phraseology used in section 222C of the Code of Civil Procedure and clause 2 of Article 26 being in perimeter, the decisions of this court rendered on interpretation of section so and so shall apply to writ proceedings also. Before proceeding to discuss the matter further, it may be pointed out that the entire bundle of facts pleaded need not constitute a cause of action. As to what is necessary to be proved before the petitioner can obtain a decree is the material facts. The expression material facts is also known as integral fact. Thereafter, my lord, keeping in view the expression used in clause 2 of 226 of the Constitution of India, indisputably, even if a small fraction of cause of action accrue within the jurisdiction of the court will have jurisdiction in the matter. And Navin Chandra, your lordship.
She is not regarding a quashing of her. Here is a Kusum ignored.
No, in Navin Chandra, territorial regarding
Because
territorial.
here it is a case where the entire cause of action arose somewhere, a notice was issued, and it was the notice was challenged in somewhere else. So that was the issue.
On the
You answered that question whether there are two different cause of action. First is a cause of action to file a complaint. That will have bundle of facts.
my lord.
What are the bundle of facts? One is that where the contract was executed, where it was disobeyed, when payment was made. All these may be relevant considerations.
My lord.
Okay.
My lord.
So therefore, Calcutta Court taking cognizance of such a complaint
My lord.
is without jurisdiction,
My lord.
according to you.
My lord.
Now, rightly, wrongly, the cognizance has been taken in a complaint case.
My lord.
Therefore, the Calcutta High Court may say, no, you don't have the jurisdiction because all these cause of action are there. What are you challenging is a cognizance order of a court which is not under the jurisdiction of this court. Then two different cause of action. What is cause of action for the complaint? That, of course, can be looked into by the Kolkata High Court.
Why 226 has been incorporated in my humble submission, my lord. That's why in Bhajanlal also, in Calcutta High Court, there is no occasion to file under 226. I can file under 482.
Yeah, of course, 482.
But why 226 to when the process has been
No,
abused?
I think we will commit the same mistake. What the magistrate has done, we will do the same thing if we entertain this petition. Take time, day after tomorrow.
My lord, this honorable court also, if your lord see.
We understand because there was a notice, there was a stay. We have
That
now.
Aligarh, my lord, NIA case, your complaint case, your lordship.
Huh.
Justice Bhuiya has quashed the proceeding, your lordship. After considering only 226 2.
See, that is not convincing us. We may differ with that view also. That's why otherwise I would have immediately said, this is my, you clarify it, these two views, then we'll rely on that judgment. A ratio is binding upon us, clarify the ratio. Is the, whatever the question I have put, is it dealt with that judgment? No.
But my lord, once again, your lordship kindly see.
No, if you want to proceed, we can proceed.
My lord,
There is no problem on that. If you want to proceed, we can
my
proceed.
lord,
Yes, so
Bhajanlal,
give us
for
the
a moment,
Bhajanlal.
your lordship.
Yes. We are taking a, but don't take adjournment of a few minutes, after a few minutes.
That, my lord,
That's why I'm giving you a chance to, come prepared. And if you are prepared, we don't have any
I
problem.
have tried to convince your lordship.
No, so that's why I'm saying, try to convince. If I'm not convinced, then don't take time. Okay?
On Wednesday, your lordship.
My view may be,
29.
may not be correct. I'm not saying that my whatever view I have expressed, that may be wrong. But we are open to ideas. I will like to get my views to be wrong. No problem on that. Okay? So therefore you come prepared.
Wednesday, your lordship.
Wednesday.
We'll try, your lordship.
Uh,
Deeply.
Learned counsel for the petitioner seeks some time to prepare and address this court. Full stop. That is allowed. Please this matter on Thursday. Next.
Thursday.
Please, your lordship.
Yes.
Your lordship, in this matter, your lordship, we have challenged for setting aside the order dated 29 your lordship, by which your lordship, additional district judge, your lordship,
Where? Impugn order ite?
page 29, your lordship,
Page 20.
29. Sorry, your lordship, page 44.
Page 24.
45, your lordship.
45, last page.
Attachment order has been stayed, your lordship. Right. Attachment order dated 7/2/2024, your lordship.
Where is that?
Page 37, your lordship. Now may I draw your lordship attention to the grounds upon which the same has been challenged, your lordship. Page, one ground has been stated, your lordship, page 41, your lordship,
Page.
page 41. Your lordship. Point number 2, your lordship. For that the land court below failed to fix any date for hearing of both the sides in absence of any, and in absence of hearing of the second party revisionist, the finding of the lower court, which is reflected in the impugn order dated 7/2/2020, is not. But on reflection, on perusal of the order dated 7/2/2024, your lordship, the additional district magistrate, your lordship, has fixed the date of hearing on 5/3/2024, your lordship. Lordship, kindly paraphrase 37.
What is your ground of challenge?
Actually, your lordship, the scheduled land has
That cannot be a ground of challenge. That is the facts. We cannot entertain.
actually,
the
your
fact.
lordship, the land.
Why this order is wrong? Tell us.
Actually, your lordship, the land has been purchased by the.
So these are facts. What is the ground of challenge of this order?
Actually, your lordship, the order dated 7/2/2025 is an interlocutory order, your lordship, and for
That can be a ground. Hard. So, Mr.
Kemira, your lordship.
Huh?
Kemira.
K. Meera, learned counsel for the petitioner. The present application under 397/401. The present criminal revision petition is filed assailing an order dated 29/2/2024 passed by the learned additional session judge FTC, Kachar Silsar in criminal revision number 18 of 2024. Full stop. The present petitioner, no, Taragot Likha. What is the magistrate's order? Yes,
Page 37, your lord.
come on. Comma. Learned no, additional district magistrate Kasar Pilsar by an order dated 7/2/2024, comma, on the basis of police report suggesting that the dispute between the parties therein may lead therein involving possession of a disputed land may lead to a serious apprehension of breach of peace and public tranquility, comma, directed by an directed attach the land under section 146 within bracket 1 of CRPC and restrain both the parties from entering into the disputed land until further orders. It was further expressed in the said order that considering the emergent situation, the order was passed ex parte. The matter was fixed for hearing on, where is the date?
5/3/2024.
Where do you get that?
Above line, the schedule line explained.
Okay, the next date of fixed was 5/3/2024. Being agreed by the aforesaid interlocutory order, the respondents herein preferred a revision petition before the learned who?
Session judge, your lord.
Learned session judge Karimganj,
No, your lordship.
Kachar, district session judge Kachar. Full stop. Such petition was transferred to the court of learned additional session judge.
Yes, your lord.
Learned additional session judge, comma, FTC, Kasar Silsar, full stop. The learned judge, by an order dated 29/2/2024, while admitting the revision, stayed the order dated 7/2/2024, passed by the learned additional district magistrate in exercise of power under section 146 within bracket. The learned counsel submits that such revision petition was not maintainable inasmuch as the same is an interlocutory order. This matter needs further consideration. Accordingly, issue notice considering the nature of the order passed, comma, it is provided that the parties shall maintain status quo in respect of the dispute and in bracket subject matter of the criminal revision number 8 of 2024. Any notice to Mr. Parasar? One.
Challenge here is, my lord, of the charge sheet, my lord. Well, I have taken the plea of LAV, my lord. My lord, if a lordship turns to the last, my lord, page 29
Who are you?
No.
You are the main accused.
Are there. One was arrested, and earlier I approached this court, my lord, by way of an anticipatory bail. But that bail application was withdrawn on the ground that charge sheet was filed. And there was a direction to the effect whether I was admitted in the government hospital or not. Because I was admitted to a hospital that is out of state, my lord. Page 29, my lord, it shows from the government record, my lord. I was in the hospital, my lord.
To prove all this,
My lord.
Why should he quash on this ground?
No, my lord, lordship may call for the record.
No, no, no.
Because if
The
the
materials available will not warrant. Not at all. What is your name?
my name is Sultan Hussain, Sultan
Sultan
alias
Uddin.
Sultan Uddin.
Let us see the FIR first.
FIR, my lord. FIR, your lordship will find, my lord, at page 15, my lord.
Your name is?
Sultan Uddin,
Sultan.
Sultan Uddin.
Do-
2 নম্বর আসামি, my lord.
Where is your statement?
My lord, page 6, paragraph 6,
Case 6.
paragraph 6, my lord.
Once I have seen that one investigation is properly done. After many times. Forensic,
Yes,
everything.
yes, that's true, my lord. If your lordship turns to page 26 of the charge sheet, my lord. The second last paragraph, my lord, has the case is well established against the FIR named and arrested accused person so and so. And absconding accused so and so, my lord.
Mobile was seized.
Yes, that. Or your lordship may give a direction to the court below to file in regular bail. I'll approach the matter. On that line, my lordship may dispose it of, my lord.
Heard. A. Dutta, learned counsel. Present application is filed. 82 of the Code of Criminal Procedure. Assailing. Stated against the petitioner. That is, where is the case number? Special POCSO case number of 2023 arising out of Bajari Chera PS case number 230/2023 under section 431/376 bracket 1 IPC read with section 4/17 of the POCSO Act. After completion of the investigation, investigating officer submitted
19 to 24.
charge sheet on
19 to 2024.
19/2/2024. The charge sheet also reveals that Girl was duly medically examined, comma, the blood and semen were sent for forensic examination, and after completion, search sheet was filed. The Dr. Learned Counsel submits that petitioner he will not pursue with the present challenge. However, a direction may be issued, petitioner may be permitted to file a regular bail application. The learned court, trial court below in as and to be, he has declared to be an absconder. Of the aforesaid, the present closed with an observation that liberty to the petitioner, file and regular bail application of learned trial court below. The learned court considered the same in accordance with law. No, nothing further. Mr.
I'm not asking anything, but one submission may be recorded, my lord, that the plea of alibi is possible, my lord.
The learned counsel report taken a taken plea of LIB. However, this court will not plea at this stage. Party to raise as and when
I'm deeply aware.
Yes.
482 application, Lordship, the complaint as well as the order taking cognizance is under challenge, Lordship.
Why?
No offense is made out against the petitioner. Lordship finds the impugned complaint from page 44 to page 60.
Arbora,
Lordship, Arbora.
Mr. Arbora, learned counsel. In application under section 482 of the Code of Criminal, assailing a complaint, assailing the proceeding of CR case number 07/2024 pending trial, pending in the trial court, pending before the learned judicial magistrate first class Karbi Anglam Difu. The aforesaid CR case was lodged on the basis of a complaint filed by the respondent number 2.
Respondent one, only one respondent.
Also respondent number 1. Full stop. Peruse according to the learned counsel for the petitioner, no offenses under section.
Section 294A, 500 as well as 67 of the
Section 294
A.
A slash
500 IPC, read with 67 of the IT Act,
500 IPC and read with section
7 of the IT Act.
67 of the IPC is made
IT
out.
Act, Lordship.
IT Act.
Information
IT
technology.
is made out, full stop. Peruse the complaint petition and also the statement of the complainant recorded under section 200.
Lordship, that statement I have not
That is the important. I have seen somewhere,
complained as well as the cognizance order is there.
right, complaint, but that is important. How do you know that? Learned counsel for the petitioner prays that he may be granted a week's time to
I'll I'll obtain it.
buy up an additional.
Lordship.
Learned
Within this week, I will file it, Lordship. Within, I'll file it.
learned counsel for the petitioner prays that he may be granted 3 days time to bring on record the statement of the complainant recorded under section 200 CRPC by way of an additional. Prayer is allowed, list accordingly.
Okay.
Yes, what is this 58?
Matter parties Zimma, my lord. In vehicles collided. One vehicle, my lord. 30 numbers of back. I am the owner, my lord.
By
After
the owner of the betel nuts.
settlement,
Call for a record, Quinn.
Good.
Where is the betel nut now?
Betel Nut is under the custody of policemen.
Let's have a report.
Zimma was granted by the CGM. However, my lord, by misleading the code, my lord, the prosecution filed revision before the learned. However, my lord, on that date, the revision was not filed. but police did not hand over the Zimma, even though the Zimma order was granted. Subsequently, my lord, after 1.5 months, my lord, the prosecution filed a revision petition,
Anyway,
which was stayed, my lord. Subsequently, on being aggrieved with this order, before your lordship.
To call us.
can we have to issue notice and call for the case there?
Till then, my lord,
Till then what?
Till then,
that order may be stayed, my lord.
Then you will have
It
the,
will have the
you will
Zimma.
get the entire relief. Interim order
That
will
is
amount
the
to the
main-
final relief. Is it permissible? Why do you make
I
certain
leave it to
prayers?
lordship.
We are very liberal granting relief.
I'm leaving it to lordship.
Don't make this kind of,
that is the main pair.
that will be, this now, this will become infractious.
Notice may be issued.
Hard. Learned, hard Mr. R.
HR.
HR Chaudhuri, learned. Present application is filed under section 482, assailing an order dated 9/5/2024, passed by the learned session judge Karimganj in criminal revision number 17 of 2024. First of, by the aforesaid order, the learned session judge has stayed an order dated 02/04/2024, passed by learned Chief Judicial Magistrate, granting Zimma of seized betel nuts, seized in connection with GR case number 1290/2023, arising out of Badarpur PS case number 154/2020. Full stop. Notice returnable on. Returnable on.
Only we had a maybe fiction,
Give a date when we can, you can have the report.
10 copy also, 5.
Returnable on 5th of June 2024. The case diary of
No, charge sheet scan.
charge sheet file. Okay, registry to call for the scan copies of the proceeding. Copies of the proceeding of GR case number 1290/2023, along with the case diary of Badarpur PS case number 154/2023. Considering the nature of allegation, in the interim, it is provided that the further proceeding before the learned sessions judge in criminal revision number 17 of 2024 shall remain suspended and shall suspend. We are not staying the order. However, it is made clear that this court has not interfered with the interim order dated 9/5/2024. Otherwise, if that process, nothing.
Well,
Please.
The lordship 79 days lordship. I am not on merit lordship.
Where is the affair?
Page lordship 9 lordship.
Yes.
9. Getting to some fake currency lordship, but nothing has been recovered from my possession lordship. I have and all the seizure list lordship.
You are in the group 37 lakhs.
yes, 37,88,000. Not from recovered from one Abu Hanifa, but he is the person who handed over all this fake currency to Abu Hanifa.
Currency difficult.
79 days lordship.
So what?
Here's the trial lordship. I'm ready. And the RCT submit.
Face the trial with of state hospitality. That is what we want. If they want to, but they do not, they will not give you that hospitality. They will fail in filing the charge sheet. They will automatically give
Submission
you,
is
but
made.
will not do that.
My learned friend lordship, on as per the statement of the co-accused lordship, but recovery is concerned lordship, nothing.
They are already under custody,
Not-
some under other cases.
No.
No,
No, lordship.
yes.
You are Mohammed Malik.
I am Nizamuddin Lordship.
No, madam.
Nizamuddin alias
He is
Nizam Munshi.
Mohammed Nizamuddin Khan
Mohammed
alias Nizam Munshi, madam. Your lordship may kindly peruse statement of Malek Ali and my lord Abu Hanifa and the present accused, madam.
One more person is arrested in connection with this case, Lord. They were carrying the money, Lordship, but I have been picked up from my house, Lordship. But nothing. Search was conducted in my house and some relevant
Lord.
length of detention may be considered.
Lord. Kotakur learned edit. Is there investigating authority collected sufficient incriminating material so far collected also suggests that petitioner is part of a larger group who dealing with manufacturing and distribution of fake currency notes. Correct? As asked by Mr. A. No recovery has been made from the petitioner. However, the material collected by IO suggests that the petitioner is part of a group who are dealing with fake currency note. The fake Indian currency note recovered was to the tune of almost 37 lakhs,
37 lakh 88,000, madam.
almost 38 lakhs. 8 lakhs, full stop. The case diary further reveals that there may be some other persons and police are trying to apprehend them, full stop. Considering the stage of investigation and also considering the nature of allegation and involvement of the petitioner, this court is of the view that the petitioner has been able to fail to able a case for grant of bail. According to present petition stands, this case diary be returned back.
Lordship, and amounting is 1 crore, Lordship.
Huh?
1 crore 37 lakhs.
1 crore 30.
That was 37 lakh 88,000.
Huh?
37 lakh 88,000.
37 lakh 88.
Published, Lordship, published. May I please, Your Lordship?
Yes.
Last seated case, scan copy available, I have gone through.
Want to?
Lordship, I am appearing on respondent number 2.
Okay, where is
I
the
have
FIR?
already filed a Ukalat number, Lordship, on behalf of appearing B. Kupang, Lordship.
Where is the FIR?
FI is at page 12, Lordship. And
Yes.
particular is at 16, Lordship.
This is Shivsagar. I have rejected earlier.
Yes, Lordship, before conduct.
I have
trial,
rejected this case.
Yes, Lordship, at the initial stage when the case was not searched.
Not the,
No, that we understand, but
Yeah.
I have rejected
Yes,
this
yes,
after looking at the many students. Many students, not a single
out
one.
of 10, my lord, 5 examined, my lord, PW 1 and 2 are the main victims, my lord. And this is a disease, my lord.
Huh?
Kind of disease, my lord.
Disease. I have seen that. I recall this case that all this small child, somebody did not
Yes, yes,
disclose
my
it.
lord. He is a, my lord,
Out of
martial arts-
fear, when it was disclosed, everybody came forward and everybody disclosed.
the martial arts, my lord, coach. my lord.
I recall it. I recall it. Yes, this is my order is annexed.
Exam, my Lordship, last 200.
How many witnesses are there?
Out of 10, 5 witnesses examined, my lord.
But no benefit of being
Madam,
there. Better
he
you
should
take the
be-
benefit of being there.
Yes, my lord. For the society, my lord, he should be.
For not only the society, for yourself also.
Yes, Lordship, I understand.
You be there for some time so that we can have a handle that, okay, all throughout the trial, he is inside at the stage of appeal.
Now he has 2 minor daughters, Lordship.
Hard.
Benefit should- Lordship, as evidences must progress, Lordship. Now, official witnesses are to be examined, Lordship. At least granted to bail and trial will be not frustrated, Lord.
That's correct. That's
Case is bad,
correct.
Lordship. I understand, Lordship. Case is bad, Lordship.
That if case is bad, cases have examined in
Yes, Lordship.
in so much of clarity.
Yes, yes, my lord.
What is the benefit? Dismissal or withdrawal? To approach the learned session judge.
Already I have approached.
Hard. Mr. Sir?
Yes, Lordship.
Yes, Ali, learned counsel for the petition. Sir, learned additional public put.
He also for the informant, my lord.
Mr.
Actually, I am appearing from B. Fugan, Lordship.
One is here in,
He is undergoing treatment, Lordship.
that cannot be. Cannot record anybody's name. Also heard the learned counsel for the respondent number 2. Present application under section 439 of the Code of Criminal Procedure 1973 is preferred by the accused, namely Jalaluddin Ahmed, who is in custody facing trial in connection with
Official POCSO case number 78/2023.
arising out of Shivsagar PS case number 147/2023 under section 377 of the IPC. Read with section 10 of the Protection POCSO Act 2012. Full stop.
6
6 of the POCSO Act.
and 10.
6 and 10, huh? 6 and 10 of the POCSO Act. Full stop. Here is the 10 copies of the proceedings. Scan copies of the record of the aforesaid proceedings. Also peruse the statement the witnesses so far recorded, including statement of the victims, minor victims who stop. Out of
10.
10 witnesses, 5
examined.
witnesses has already been. Considering the material available on record including positions of the victims, this court deserves to be dismissed. Accordingly, same is dismissed, full stop. Expected that as only 5 official witnesses are remain to be examined, the learned will complete the trial as expeditiously. Subject to is day-to-day business. List. Okay, that's all. Yes, Ahmed.
439 application lot is behind the bar since 16/9/2023. Complain your lordship will find at page starts from page 10. The person where I'm relying on lordship may kindly say page 12 and 13.
Yes.
12 and 13. My lordship, the contrabands were recovered from a guest house at lordship,
Case 12.
page 12. Cell number 3, your lordship.
Cell number. Where is the DRI? I'll find them. Can copies has come. Wait for some time and inform them. So that they will have a chance what you have argued. Wait for some time. Inform them. Name shown, DRA name shown. Who is standing counsel of DRA? Yes, madam.
Granted to file objection.
What objection? Materials are here. It's a search case.
Yes, all records are here.
Where is Kyle?
Next in court number 4.
Okay, wait for some time. Whenever he comes, let him make up here.
Lordship may fix it at
2.
Please,
Yes,
Lordship, this is a 439 bail application, Lordship. This petitioner in jail custody for last 35 days.
Where is the
Lordship.
affair?
Affair on page 14, Lordship.
How many days?
35 days, Lordship, in jail custody, Lordship. I have not, Lordship, instead of that, they have, Lordship, picked up my vehicle, Lordship, and seized my vehicle, Lordship. But the FSSAI, Lordship, the vehicle number is different, Lordship.
What is your vehicle number?
My vehicle number, Lordship,
Yes, what is the Bothakor? Do you require his further interrogation?
My lord, till now that stolen vehicle is not yet recovered. And initially, my lord, on the basis of my lord GPS connected with the vehicle, my lord, police, my lord, collected the my lord CCTV footage of a petrol pump of Barnihat area. And thereafter, my lord, police arrested one Ali Hussein and Ibrahim Ali. And thereafter, on the basis of their statement, my lord, present accused person was
What is his role?
his role is that he is the person he paid money to the other 2 accused persons. Thereafter, he took the other 2 accused person handed over the vehicle to the present accused. Then thereafter, the present accused sold the vehicle to a person at Nagaland. That is the statement of the my lord, present accused also. Another accused also stated that my lord, by taking money.
Now, what about that Nagaland who has purchased the vehicle?
That was my lord, regarding that investigation is going on, but stolen vehicle is not yet recovered. My lord. These are my lord, gang of my lord lifter, my lord, vehicle lifter.
Where is he now? He is in judicial custody.
Judicial custody. My lord,
35 days, Lordship.
Investigation is going on. My lord. Vehicle not yet recovered.
They could recover.
But
Lordship.
vehicle, you are not even in fact trying to go to Nagaland to recover the vehicle.
lord.
That is also true, isn't it? Now, what is happened is happened. We have picked up this. We'll file the search sheet. Vehicle, forget about the vehicle. The case is true, but vehicle could not be recovered. They will get the insurance.
These are the gang of my lord, those.
No, we understand. But how many days you are there?
35 days, Lordship.
What is the period? 60.
60 days, Lordship.
alleged in the FIR that that some unknown person stolen the vehicle of the petitioner, informant bearing registration number AS01JC318C. Sorry. In the vehicle, full stop. On the basis of GPS location, accused persons were arrested. However, the vehicle could not be recovered as, according to the said two arrested accused person, disclosed that they handed over the vehicle to some people in Nagaland, and they have
The present accused.
to the present accused.
The present accused has sold it to someone.
And the present accused has sold it to some people in Nagaland. Full stop. Vehicle is not yet been recovered. However, considering the stage of investigation, this court is of the view that considering the stage of investigation and the fact that this three accused person has thoroughly been interrogated, comma, this court is of the view that no further custodial interrogation of the petition accordingly.
Highly obliged.
50,000 to the satisfaction of
CGM Kamrup Metro.
Kamrup Metro. Mr. Bhattako, do you have any record that this person we have released on bail? Suppose he is again arrested or he is apprehending arrest coming next on the next occasion to this court. Now he will make a statement. Always in all petition statements is made that I have never been implicated in any case. I am an honest person, this, that. Now, is it not necessary to disclose that I was earlier arrested or not?
Yes, my lord. Regarding that also one note of the IO is there, my lord. That IO is only stated that he is also involved in the IO is trying to
So that we understand, but what we are thinking is
Yes.
we will make a provision in the bail
Yes.
that if there is any arrest in connection earlier,
Yes.
he should disclose the specific
But
things.
in many cases today, my lord, now, my lord.
More
police
particularly,
disclose that-
439, this might not have
Yes.
very relevance,
Yes.
but 438 it will have relevance.
Yes. Yes, man.
He will come and make a statement that I have never been in, because these are the conditions. So either in FIR, either in affidavit or somewhere, we'll have to make a provision.
Earlier, my lord, what happens, my lord, police never disclose all those earlier cases. But my lord, recently, my lord, it happens that while my lord, someone arrested, then police, my lord, in the forwarding report itself specifically stated
That should
about
be,
the
because
number
there
of
are
cases.
some, now this system is, all are integrated.
Yes, ma'am.
Police software, police station. After
ma'am.
someday, we will have this blue link in the FIR also.
Yes.
Moment he will type the FIR, that so and so is annexed. That moment he types the FIR, he can link to it with the,
Yes.
he need not go to the PI's code. Then we can click it and see in our computer that this is the FIR. That's why I'm asking is,
Yes.
these are the problems in the filing system. So we want to understand actually what should be necessary so that we can incorporate it. Now probably the phone numbers will also be declared, liable to be declared in. Because otherwise that problem will happen. The IO says I have not received the interim order, so arrest him. Now moment we pass an interim order, it will go to a designated phone number so that IO cannot say, and we will give a declaration that this means the IO has received it. Is one area we'll have to look into. Yes, next case.
Highly obliged.
Yes, Mr. Kotoke.
So in this case, informant was made a party in this case, my lord, and notice has been issued, but complete or not that.
But in the office, lordship, to
Now scan copies received.
receive.
Acceptance notice has been received. What is acceptance notice? This is POCSO or what?
POCSO.
You have taken steps.
Yes, put up PP, my lord.
Uh-huh.
The prosecutor has issued notice, my lord. that
Okay, you-
I have inquired in the morning also. We have not received any instruction. So if lordship,
Also, my lord. Full version is totally. Version, my lord. Two witnesses were examined, PW1 and PW2. PW2 is the victim. In which he narrated the incident. Medical report is totally otherwise, madam. Everything was intact, madam. Is it less than 10 years, madam? It's 21 year lordship in constancy. Thing has happened.
do 9 years. Now,
Your lordship say kindly see.
no, see, if we want to allow this, then notice will be required. For
Yeah,
dismissal, dismissal notice is not required. Suppose we propose that we will give you a bail, then it will be necessary. Yes, you have instruction next week. The B. Sharma Larnet, additional public prosecutor, submits that he is awaiting report from the investigating officer as regard service of notice upon the informant / respondent number 2. Accordingly, he prays for an adjournment. Prayer is allowed. List this matter on when you can have it. Give a date as per your
Friday.
Friday.
Okay.
Have it.
already कुछ हो 25 and 30 can be taken up together also. Arising out
5
of
and
the same-
30. Who is for 30? Both for
Lordship.
5 and 30. Okay.
Can you take up 25 first, Lordship?
25 is AB.
Yeah,
B, all B.
This case, an FIR has been filed against me. Lordship would
Where is
find
the FIR?
at page number 14. Is most respectfully state that on 17 to 2014, at around 6:30 AM in the morning, when I was tying my kettle inside the stable, the below mentioned accused person came there with a dowel, untied the kettle, removed the post from the kettle where it was tied. When I saw my kettle coming out of the stable, I went to see. At that moment, the accused person chased me with an intention to kill me. However, I managed to run away from them and save my life. The accused person cut down all the trees near my residence when they failed to kill me. Having no other alternative, I went to Pathori Ghat outpost to file an Ezahar along with my husband living.
Now, who is the other person? First is Rekibul.
Yes, Lord. Rekibul and his husband, his father.
One
That
is Rekibul
that
and one
item
is
number
Sahabul.
30. Sir, Lordship, whatever the allegation is, Lordship, may kindly turn to page number 37 once, Lordship. Before
37?
anything, Lordship. 37. Lordship, I'm working in a hotel called Abhishek Regency in Guwahati. And this is what they state, Lordship, on 8/5, Lordship. This is to certify that Rekibuddin Ahmed, so and so, working as a housekeeping in charge of for the past 14 years in our hotel. This letter to inform that he was working at the hotel in the month of February and March 2024, as he did not take any leave. He took leave for 2 days in the month.
Oh, these
as-
are matters of trial. Whether that
Yes.
document is genuine, whether
sir.
he has issued an interested party, these are matters of
But
trial.
my plea is that,
Let us see what is the case, what is in the case there.
Lordship,
Is a defend dump.
now, Lordship, if taking advantage of a fact that somebody is dumb, a false FIR has been filed against me, where I was working in Guwahati. I was not even present in the scene. Now, everything has arisen from a end dispute, Lordship. Lordship, may kindly see, Lordship.
Just a minute, just
Yes,
a minute.
Lordship. Yes.
You are saying that she is a different dam.
Yes, that I do not know, Lordship. I was not even present in the scene, Lordship. It is their case that she is the defendant. Lordship may permit, Lordship.
Medical report, Mr. Bhatt.
There is no in the case. There
Huh?
is, it was,
How many days they are behind bar?
On 8th, 5 was
What are
arrested.
the offenses registered?
Princess are Lordship,
354,
B.
354B, Lordship.
What is the age of this girl?
22 years, Lordship.
Lordship.
Mr. Deka, she is a different dumb lady, but her statements were recorded on with the help of a person who is expert in this
I
regard.
understand, Lordship.
The teacher in
Ah.
different dumb. So she has vividly explained how you have done it, and she has identified you when you both of your photographs were shown. He said that I do not know them, but when your photographs were shown, she has identified this is that.
I understand, Lordship. Now, may I submit?
He said many things against you, whether it's 354B or it may go further, we do not know.
If I may submit,
Maybe civil dispute. We are not saying that there may be civil dispute, but from a statement of a deaf and dumb girl, it's absolutely clear that house was attacked and she was also attacked and she had injuries. Photographs, we did not believe the photographs, so we wanted the medical report. How many days you are behind bar? 19. We are returning back the case diary for the medical report, or otherwise we are rejecting it at this stage, taking the Decca Learned Council for the present application is filed under section 4 of Criminal Procedure 1973. Case diary, there is this produced first. The case diary, the medical report is not available. Accordingly, Mr. B. Sharma, Learned Additional Public Prosecutor, submit may be granted a week's time to return back the case diary to the IO and update the same and incorporate the medical report of the alleged injured victim. There is allowed. List this matter on
10th of June, Lordship.
10th of June.
Lordship, regarding
Any interim?
10th.
List this matter along with, list this matter on, give a date. 10th. For production of case diary.
Please, your lordship. Lordship, in this case,
Where is the affair?
page number 16, lordship. 13, lordship, type 4. On 3.
What is the CD is there?
Yes, Lordship.
What is his role? How many days?
23 days, lordship.
10 days is still required. Other was on 35 days.
Lordship, there are 4 persons who are involved. They are dealing in stolen vehicle. Admittedly, the vehicle was sold off to this petitioner, Lordship. Deals in this type of activities, admitted. And Lordship, the seized vehicle, the stolen vehicle was seized by him, Lord.
From his
As
person.
shown by him, Lordship. He led the police to the stolen vehicle.
I purchased, lordship.
You purchase knowingly or unknowingly. That is the issue.
Lordship, even if we admit, Lordship, that he purchased it unknowingly, but what was the need of changing the number plates, Lordship. That was done as per his instruction. Yes, clearly stated the modus
Mr.
operandi.
B. Chaudhary, B. Sharma, learned additional public notice. May be regarded some further time to get an updated case diary. Prayer is allowed. List this matter on
10th of June.
Fourth lordship.
is fourth. Okay, fourth.
Fourth. Highly applies.
Yes.
So Lordship, 439 of CRPC. Commercial quantity 21C and the accused was arrested on 15/6/2021.
Hmm.
Today 1000 of 76 days in completed.
How many witnesses?
Witnesses is 8 witnesses.
How many examined? What is your role?
Yes, Lordship.
You recovered from whose position?
Actually, Lordship.
Have you gone through it?
Okay, my lord, one thing, my lord, I want to, my lord, there, my lord, PW4 is examined, but regarding 2 and 3, it is PW1, and after that, PW4 is there. About 2 and 3, my lord. there
Now,
is
tell us what is the, where is the affair?
whether 4 examine or 2 examine, that is.
We'll have it, but what, let us see first, understand the
Lordship, lordship.
case. Now, page 8. Who are you? What is your name? You are Samir Khan.
Is 14 seizure list, my lord.
Restriction of the plate.
Who are examined, Mr. Bhattakar?
Lordship,
Lordship, one is named.
3 are the, 3 seizure witnesses are there. Out of them, 2 examined, my lord.
Who examined?
Who
What did they
examined?
stand?
They said that, my lord, they were present at the time when,
Let us see. They are
yes, I have like, my lord, 1 and 4, my lord.
Passing.
Now,
One of the good citation I have,
what is the,
Robi Prakash versus the state of
what is the law?
paragraph number 3 and 4. 3 and
How many days you are behind bar?
Lordship, 2 years, 9 months. Yes.
Here in terms of the judgment, 1 year. To take this is not as ratio. Didn't give it.
In this case, your Lord, 11/11/2021, and the page number 32. 32, page 32. Order dated 10/4/2023.
30.
In this case, the Honorable Trial Court issued a summon to the IO for personal appearance. Your after then, date was fixed for 24/20/2023. And the
What
next
IO
week-
is IO has appeared.
No, Lordship, not the order of 2010/4/2023. After then, again, order has been
Now,
passed.
how many witnesses examined? You are doing the trial.
2.
Now,
Yes, sir.
then why this is marked as 2 and 4?
Strongly come, your Lordship. On the last occasion, I have already. Quote, your Lordship.
Okay, that is by mistake this has
Yes,
been.
Lordship, by mistake.
So according to you, only 2 witnesses examined.
Yes,
Now, how many total witnesses?
8 witnesses.
7 as per the PS.
7
Lordship,
witnesses
all
to
the
examine. What was the last date of examination?
Next date is fixed on 18/5.
5 is gone.
What happened on that?
What happened on 18/5?
18/5, no witnesses come.
No witnesses has come.
And this witnesses has been examined 8/4/2023, last one.
Are those,
for total.
does
Name
this
is Subhash-
does this
Subhash
record
Singh.
reflect
The Caesar witness.
that it is reflected in the order?
Lordship. Kindly matter may be taken up tomorrow, your Lordship. I will be submitting.
Okay, you have the copies. We are taking it
Yes,
up
sir.
on Thursday. If necessary,
Yes, sir.
we'll direct the IOs to be present on the next date. We'll communicate to him. Okay, let
I
us
will
see.
personal direction
So you give us those orders. We'll take it up day after tomorrow. Okay,
after tomorrow. Okay, Lordship.
let this matter be listed day after 29th.
Achha.
And if you can have the copies, even it is downloaded from the site, we don't have any problem.
I will take certified copy, your Lordship.
Mail কে type করলো? Arta to tip. Yes.
In the meantime, my lord, any record can be called from the my lord, because from Guwahati, my lord.
Yes, what is this?
Scan copy of the case. What has been called for, my lord. It
Receipt.
has come.
You gone through it, Mr.
Yes, my lord.
What is
Yeah,
the, where is the affair?
FI is at page 12, my lord.
Yes.
12. my lord. $28,524 is fixed for consideration of charge. For flag mark.
When the offense was committed?
My lord,
Alleged offense?
Four, four,
Four.
seven,
4723.
we arrested on 7/7/23.
Arrested.
Yes, ma'am.
Medical examination done on
Yes.
when?
My lord, immediately, my lord, then medical report is there.
What is the case diary?
10 copy has come, I have flag mark, in 164 I have flag mark.
What is your name?
Rahmat Hussain. alias Akmal Hussain. False allegation, my lord, medical.
Problem is this medical report is not so important in these cases.
Investigation, my lord, consider.
Thakur,
my lord.
Goswami,
Sir,
what is the statement of the other persons? This, according to her, she was rescued.
Yes, my lord. Perhaps one is absconding now, my lord.
No, that is fine. She said that he was my boyfriend. He asked me to elope with him. I refused. Then he said, I'll kill you. Then in threat, she went with her. And on the way to her somewhere, then medicine was given to her. Then she became unconscious. And thereafter, somebody found him near a bridge.
Yes.
She was rescued to a residence of
Yes,
somebody else.
that-
Where are those?
Yeah, that part, my lord, the PDA part I have, and regarding witnesses, sir.
Just go through it.
Yes, I did.
We'll take up at 2. You go through it.
Taken before one, my lord.
Okay,
I will
no
be
problem.
here, my lord.
No, you go through it. It's here 4 copies. Okay, no problem. You go through it. Yes, next case. Just look into that.
Yes.
What are the other things? Because
Yes.
on 4th it happened. Immediately on 5th she was examined. She was absolutely normal.
Yes.
And her statement admittedly, and what is your age?
Age is, my lord,
Rahmat's age?
Rahmat is 22.
22. And she is more than 16, around 17. And this is the story. So these two statements of the other two are very vital.
Yes.
Okay. What is this?
Regarding, my lord, yesterday,
default bill, my
Yes.
lord.
regarding the default bill, my lord.
What you say?
Yes.
Yes.
Yes, my lord, I have something to say in this case, my lord.
Yes.
My lord, first, your lordship will sign, my lord. I am placing my 167(2), my lord. Just one explanation, my lord. What it says, my lord.
CRPC.
Yes, CRPC, my lord.
167(2).
167(2), my lord. The last explanation, my lord. The below, my lord, explanation
Just a
1.
minute, just a minute. Two, yes,
Yes, my lord. And
explanation.
explanation last part, my lord. Explanation 1, my lord.
For the
For the
avoidance, it is
avoidance
hereby
of doubt,
declared
it
that-
is hereby declared that notwithstanding the expiry of the period specified in paragraph A, the accused shall be detained in custody so long as he does not furnish bail.
Okay, that is fine.
That is one, that is just to, my lord, my lord. Now, my lord, apparently, my lord, on the record, there is an application, my lord. Application is for the extension of the default period, my lord, and another for his default.
Can you mark it? Where do you get all this?
My lord, my lord, lordship may kindly see in the petition, my lord.
When is the application?
Page 20.
Yes,
Page 20, my lord.
20.
Page 20, my lord. There is an application by the
Original copy also find page 20.
for extension of the time period, my lord. Here, my
When
lord,
the extension of time period was filed?
11-3.
on 11th,
Before, after?
on the same, my lord, on the same day.
11-3, before filing charge sheet.
Before,
No, that is what I'm not saying. I'm saying
After 180 days.
before 180 days or
After.
after 180 days.
no, my lord, lordship may kindly see, my lord, page 21, my lord. Just, I want to just why it is not filed to it is I have stated, my lord, in the page 21, my lord, this type.
Yes,
The last line, my lord, last 4-5 lines, my lord.
yes.
That, sir, to complete the investigation required sometime, so
Just a minute, just a minute, just a minute.
one,
Till today, FSSAI
4, 5,
Kalibar Guwahati have not yet been able to collect submitted that, sir, to complete the investigation requires some time, so cannot release the arrested person at this stage. Have been
Yes.
attempted to submitting the there are some
that is why,
explanation.
my lord.
According to you, there are some explanation.
Then, my lord, on 11-3, the application has been filed, my lord. On 11-3, application has been filed for extension, this application, and also on 11-3, the prayer for default has also, my lord, filed, my lord. Now, my lord, it's just one
When this application for default bail was filed?
on 11th, on the same date when. On 11th, same date.
That application is part of this record?
No, it is not part of it.
Not part of the record, only my order is there on
Order is
11th
there,
Street,
Page 18.
page 18, my lord. The extension order and rejection of the default bill.
According to you, the period was over on which date?
8-3.
8-3. 2024.
Yes, ma'am. And on this days, my lord, there is no application. my lord.
According to you, on 8-3-2024, no application was filed.
No application was filed
Extension was sought and default bail was sought on
on only 11th,
11-3-2024.
11-3.
Charge sheet was filed on
29-3.
29-3-2024. So
Yes.
according to him, on 29-3-2024, application, no, according to you, no
Yes.
application was filed.
Right.
According to him, that was already rejected on wrong premises because on that day, no charge sheet was filed. This is your case?
Yes.
Okay.
Now, another thing I like to place, my lord. There a notice is required to be given, my lord. The extension, my lord. But in the NDPS, my lord, it was a mandatory.
This
in
is
term-
NDPS or what?
NDPS, my lord.
Okay.
In terms of UAPA, my lord, there specifically mandate is there, but there, my lord, 36A, my lord. There is, my lord, just I was
Just a minute.
finally
36A.
36A, my lord. 36A, subsection 4, my lord.
No mandate.
No mandate, my lord. And provided, in the proviso portion, my lord, provided that if it is not possible to complete the investigation within the said period of 180 days, special court may extend the said period up to 1 year on the report of the public prosecutor indicating the progress of the investigation and specific reasons for detention of the accused beyond. Though no mandate is that, you have to give notice to the accused person, my lord. That part is clear. So, my lord, the learned magistrate taking an application simultaneously with the default bill and
Now,
also
what happened to this application? Extension was granted.
extension was granted and default bill
Huh?
rejected.
Default bill rejected, extension granted by the impugn order.
Impugn
That
order.
is under
That
challenge.
is under sir. Now, my lord. So as per this section, my lord,
Where is the page of the impugn order?
Page 8.
page 18 in
page
the
18,
petition, my lord. My submission is that, my lord. the learned trial court, my lord, taking the application simultaneously for the default bail and also, my lord, and the prayer for extension is not illegal, my lord. Document, my lord. I am placing one judgment, my lord, but the law has said, my lord.
Yes. Which judgment?
Yes, ma'am. I am giving the copy, madam. Paragraph 15, ma'am. Copy, mass, I am permitted to read from my mobile, madam.
Paragraph 15.
Paragraph 15, madam. From my lord, the constitution bench, I am reading, my lord. This is paragraph 15, your lordship. The constitution bench in Sanjay Dutt versus State of State through CBI, while considering the provisions of section 24BB of the terrorist and disruptive activities, here notice regarding the, my lord, UAPA, my lord, had very pertinently held that we have no doubt that a common stance before us of the nature of indefeasible right of the accused to be released on bail by virtue of section so-and-so is based on the correct reading of the principle indicated in that decision. The indisputable right accruing to the accused in such a situation is enforceable only prior to the filing of the Salan, and it does not survive or remain enforced on the Salan being filed. Now the situation is Salan being filed, madam. Now, madam, filed. If already not available, once the Salan has been filed, the question of grant of bail has to be considered and decided only with a reference to the merits of case under the provisions relating to the grant of bail to an accused after the filing of Salan. The custody of the accused after the Salan has been filed is not governed by section 167, but different provisions of the Code of Criminal Procedure. In that right had, if that right had accrued to the accused, but it remained unenforced till the filing of the Salan, then there is no question of his enforcement thereafter, since it extinguished the moment Salan is filed under section 167 CRPC. Now, my lord, it is important, my lord, the division bench also indicated that if there be such an application of the accused for release on bail and also a prayer for extension of time to complete the investigation according to the proviso of such and such, both of them should be considered together. It is obvious that no bail can be given even in such a case unless the prayer for extension of the period is rejected. In short, the grant of bail in such a situation is also subject to refusal of the prayer for extension of time if such prayer is being made. If that is what the law says, madam. Very specific, madam.
But if you read further,
Yes,
if the
yes,
accused
if the
applies
accused
for
applies
bail
for bail
under this provision on
of
expiry of
180 days, as the
180
case
days
may be,
or
he
the
has to-
extended period as the case
he
may
has
be,
to be
then he
released
has
on
to be
bail
released on
forthwith.
bail forthwith.
And now, in the next line, my lord, the accused so released on bail may be arrested and committed to custody according to provisions of Code of Criminal Procedure. So it is a settled by constitution bench that is petition seeking the, this is also important,
This is
petition.
habeas corpus.
This is habeas corpus, but on the date of bail, that petition is not there, that sanction. After that also it came, then also it is said that the valid, my lord. So, my lord, now, my lord, on the date of order, my date of my default, my lord, the two application was heard, my lord, simultaneously, and accordingly, on the prayer of the, my lord, prosecution, the, my lord, default bail is cancelled and the extension is given, my lord. So
So
within that
basically,
period,
you will say that here provision of 36A subclause 4 will be applicable,
applicable.
where it is no specific case of notice is given.
Not easy to-
That is one. Second, your
Secondly,
ground
my-
is that since both the applications are to be taken together,
Together.
it is bound by this judgment.
Yes.
So therefore, was rightly taken, and
Rightly.
accordingly, bail is rejected, extension is
Extension
granted.
granted, my lord. And another judgment on the basis of this judgment, but I could not take up the copy, my lord. And also I could not take up
Give the name.
my lord, I could not get it, my lord. This is the one Karnataka High Court Division Bench judgment, my lord, where it is stated that made it clear that an oral request by an investigation agency to extend the
Oh,
custody,
that is also be an applicable. That will
if the accused fails to seek default bail on expiry of statutory period, my lord.
Okay, we'll pass this order, go through the things, okay. Hearing concluded, delivery of orders Wednesday.
Right.
Go through it, if some clarifications required, we'll call.
Yes, yes. Madam.
And no
Then-
scan copies are there.
If anything, my lord, because I am placing the
Ah.
law, my lord, if anything is required, I can submit more.
Yes,
if
yes,
there
yes.
is-
Any
if law-
confusions,
Then it can
will
be-
come back to you. That's why we have not said that disposed of.
Yes.
We'll go through. Okay. What is,
Please, your lordship. It's a 439 application, lordship.
what is the FIR?
FIR, your lordship.
439.
Page-
FIR is complaint or FIR?
Complaint, lordship. Page
What is
8.
that?
Page 8 is the complaint. Cross call for lordship.
Case is proceeding, my lords, on 10 days is fixed for evidence of the IO.
Okay, now what is the stage?
My lord, evidence is going on 10 days fixed for the statement of the IO.
Last occasion, lordship, it's on 6/5/2024. Also, the witnesses were absent. lord.
Any materials in this?
My lord, my lord, these are non-bailable offense under Assam Amendment Act.
Ah.
And my lord, the wildlife protection says, my lord, there's a presumption also. And my lord, he has given statement also that he knows. And in fact, the statement in the petition itself says that he was in possession, my lord. So my contention is that, my lord, it's to go to
On
the
what
file.
basis will consider? Only on this petition or any material? Either any material possession?
Yes,
How
my
do you
possession was
proceed?
there, my lord. Possession-
How do you proceed in this? You file a complaint.
Yes, my lord.
After seizure, you file a complaint, then evidences are taken. Where do you get those with the statement of the witnesses?
My statement of witness I have with me, my lord. I can produce after some time, I can produce it.
You produce it, you are
Yes.
taking after day after tomorrow.
Yes, sir, I can.
Mr. Gogoi submits that a day's time may be granted to produce the statements of the witnesses
Yes.
already recorded in the proceedings before.
Well, no, in these proceedings, my lords, these statements are admissible before the court, my lord.
Ah.
These are given before the ACF, my lord. That I can produce, my lord.
Okay,
This can be,
statements record, that is a kind of a case diary that what has been
Yes.
recorded on the basis of which you have filed a complaint.
my lords.
Of the
Statement of the accused, my lords.
statement of the accused persons and any other
Any other, whatever material I can bring.
is for a day's time to address this court along with the material available with and to
Alright.
produce the material available with him.
My lords.
Let's see what it is this better.
Alright.
Ah, bolo, lordship.
Lordship petitioner is interim and CD not received.
CD not received. Okay, when?
10th of June, Lordship.
10th of June, interim to continue.
If your report at the application CD has been called for, lordship.
FIR.
FR is at page 17, lordship. Indication is that, lordship, accused are the teachers of a school. Informant was the headmaster of that school.
Just a minute. Who are you? Sahabuddin.
That is a head.
A mark sheet issued by you on the basis of that they were appointed. Do you have seized the, okay,
Yes, Lordship. He has already appeared and
appeared? Also. Dispose of.
Highly of.
CD not received, Lordship. We are an interim, my petitioner is an interim, Lordship.
Allegation FIR.
379
E-rickshaw.
411.
Uh-huh.
Stolen e-rickshaw.
Stolen e-rickshaw. Who are you?
The purchaser mine.
What a purchaser. Any interim?
Yes, I'm an interim.
Hey, Harry. So, Mr.
Iboraman.
Option বাকিখিনি disposal.
If you have restaurant. Please.
Where is the affair?
FIR, my lord, at page 10. Relevant at page 11, my lord.
What is your name
My lord, Akhirul Islam
and
and Ahmad Ali, my lord.
Akirul?
Akhirul Islam and Ahmad.
Akirul
2
and
and 3. And Ahmad Ali. my
Ahmad,
lord.
2 and 3.
Number one, Abdul Mannaf was arrested.
Arrested, but he was
Yes.
caught by the villagers.
Villagers. His statement, as per his statement, he stated that Akirul requested him that he supposed to give 5 lakhs from that informant. So you people help me to collect that money.
What about this gun and all?
These are there, as per the informant statement, there. All these persons went to the house and they demanded now 10 lakhs. Akirul is supposed to give 5 lakh from the informant, as per statement. But
So
that
Akirul employed this
Yes,
person to
person.
extract money.
extra money.
And what
They-
about Ahmad?
Others, as per the statement of complainant, all are there, they point out the
What are the
revolver.
villagers say who caught hold of these people? Anybody, any statement?
Other villagers.
Because
Fatima
according to the
witness-
FIR, they raised hue and cry. Then villagers came and one was caught red-handed.
Why?
First caught red-handed.
One of us caught
Why?
red-handed. Only worry is the guns.
One more issue, my lord, if my lord is. Here in the FIR, the informant says that Abdul Mannaf was caught, and Abdul Mannaf then said that these other persons who were present. Now, if Akhirul owed money, and Akhirul had masterminded the whole thing, Akhirul was there, then informant could have easily identified Akhirul also. That part he said that no, only, and there.
No, Amar Gaware, all are
From the same village.
Same village. They identified, First of all, there are marks in the face, he said that because of the coal situation, other villagers statement also there,
What I say?
Bolero vehicle, other people, keep them, yes. 3-4 villagers, informant's wife also there and other. Pretending to kidnap the 10 years boy.
That may be an addition. That may be an addition, but coming and
Pointing-
demanding money at
Pointing a revolver in his
night
hand.
and showing guns, maybe fake guns, that is more or less there. Other part may be an exaggeration.
That will also may not be bailable because under 363.
He's the GP president, GP president.
GP president, he is the GP.
The accused is the GP president.
No, not the accused.
The informant.
Informant is it.
What is the name of the other person?
Ahmad Ali, my lord.
Difficult to argue these kind of cases. There's maybe some amount of truth, but there is a lot of exaggerations also, my lord.
Exaggerations are there, but in fact, I have not gone into the complainant and his wife, except believing that there is hue and cry. Forget about other things. But all the villagers,
Villagers, 3-4.
establishes they rush to the spot. How you have fled away,
Other person
what is everything.
bole
is
hoye
there.
gel.
Perhaps what happened was that he owed some money. He said, that, "Let us
Might be,
go and recover
might be this man has taken money in
Yes, ma'am.
in lieu of something, but this is not the way.
I leave it to your lordship.
Coming into the
Difficult to argue
night-
these kind of cases.
Hard, Mr. Swenson.
10:30 PM night.
Is there, come on. As per the story narrated in the FIR dated 15/1/2024, that while the informant was sleeping at his residence, the FIR name accused persons, which includes the petitioner's herein, forcefully entered into his house after identifying themselves as policemen from Kalapani outpost and then demanded rupees 10 lakh from the informant after pointing a gun at him. It is further alleged that the accused person tried to kidnap the informant's 6-year-old son. However, when the villagers came to their rescue, the accused person fled away, though one accused, namely Abdul Manna, was caught red-handed and was subsequently handed over to the police. Peruse the case diary produced. Also peruse the statements of the complainant, his wife, and other villagers, and also the statement of the arrested co-accused. The materials, there are sufficient incriminating material against the petitioners in the case. Considering the materials on record and also the stage of investigation, is of the view that a fit case to grant privilege of pre-arrest bail. Accordingly, this petition stands dismissed. Case diary be returned back.
I'm deeply obliged, my lord.
32, I'm sorry, my lord, CD not received.
Any interim?
And interim is not there.
Not there.
I can see 141 and notice was also issued to him, but due to some.
What is the FIR? Let us see.
87,509.
Page 10 is the FIR and the notice.
Who took money first? 29,000?
Plus the informant.
Informant. Okay, then he returned with okay. Is there?
No, CD not received, my lord.
Yes, but sir, when can you have the case diary? Earliest.
Dulyadhan,
Page
Let him
14.
appear. Have you gone through the affair? Heard Mr. Ahmed Learned Counsel. Also heard Mr. Parasar Learned Edit. Under is order dated 17/5. All for the case diary. Christopher. Yes, Mr. Ahmed submits that he would like to cooperate with the investigation in as much as already a notice under 1A CRPC has been served upon him. Accordingly, he prays that interim case diary is produced. In the case there is produced. Seen the affair, contents of the affair. From the affair, it is seen that the petitioner and the informant had some relation since long, and they had also some monetary. The dispute arose involving the aforesaid money. Considering the nature of allegation, this court is without a case for interim protection. Accordingly, all conditions within 10 days appear. Case diary will produce.
18 June, my lord.
Oblige, Lord.
18.
Yes.
Yeah, please, Lord. Mr.
No, what?
No, not motion, Lordship. Already case diary was called. Case diary was there on last occasion. Earlier it is rejected on the ground, madam. Any that has been demanded is directly passed through his.
Where is the affair?
FIR at page 8, Lordship.
Oh, that this will not grant bail. And this is not a
Lordship,
case.
co-accused is already.
No, they're not.
Lordship, he was also there, Lordship, in the vehicle, Lordship.
You do not know.
That person has been given the privilege of pre-arrest bail, Lordship. They are on same footing, Lordship. After
Money transferred to whose account?
his petitioner's account, ma'am. And moreover, Lordship, here only the non-billable section 5, Lordship, that is alleged of kidnapping, Lordship. And no one was kidnapped.
What is your
Lordship.
new ground? That granting of bail to the co-accused.
Moreover, Lordship, that 365, Lordship. Because he was not kidnapped as per the fire itself, Lordship. He was dropped from the vehicle, he said.
He was not kidnapped, and what was done to him?
He was just as per the allegation, Lordship, that money was transferred to this petitioner's account, and after that they drop him from the vehicle, Lordship.
What about the extension?
The other sections are available.
The robbery in the highway. Edit.
Accused bail has been considered. Here, Lordship will appear and cooperate with the investigation.
Accused has gone.
Yes.
You'll pass the order later on. Keep the case like. Let's see. What is the standing between two persons? Let's see.
Account,
But
my lord,
a part of the same group.
from the same group.
One is transferred, one is granted bail. We'll see if the case that.
Lordship.
I have like.
Wait, my lord, that third case, my lord.
Second time. Second time. Oh, that home guard. This is second time or first time?
The first time,
First
my lord,
time.
this is my lord.
Alcohol.
Here, my lord, I was with you.
Huh?
One co-accused, Horacio Kulte, was arrested, my lord. His statement.
See the situation.
Yes.
Now these people are also seeking anticipatory bail. Purpose of incorporation of section 438 is gone. Where is the tablet?
My lord, as per my instruction, there was no tablet in the bag. They have scanned the bag, my lord.
Whatever, what you say?
The basis of statement.
But otherwise, there is, my lord, allegation of.
Use the word otherwise. We are giving you an interim. Appear before it. We are returning back the case then.
Statement of witnesses is also there, my lord. Witnesses, they were in fact on that day, my lord. The present petitioner and one that co-accused person were on duty in the main check gate of the ISBT, my lord. That is an.
My lord, I will appear, my lord. I will cooperate with the investigation. Scan.
Other is arrested. To grant the anticipatory bail, you are the protectors of the persons who will come to ISBT. Is how it grant an anticipatory. All materials are there. The fact
Yes,
is
my lord.
correct.
Yes, correct.
Then why should we grant you anticipatory bail?
But,
Maybe small offense.
My statement may be recorded.
That will be giving a license to you. Be there in your home and come back. We'll grant you on day one. Rejected. Very good. Yes, next.
164, then your lordships will.
Yes, where is that 164?
Have flag mark, my lord. 164 is
Scan.
the LC apartment.
This is what? This is IA.
This is, no, my lord, this is
Bail from the trapez pending trial.
pending trial, my lord. Now, my lord, stage is consideration of charge.
Which page you want to show me?
164, my lord, in the later part, my lord. Last.
That I have seen. Now, two things. One is that she says that she eloped and he given some medicine. Then again, how he that's why I asked that anything.
161 statements, others and her mother. that they have recovered her from the
Heard. Heard. Also heard, Mr. The present application is filed under section 439 CRPC. In bail.
sorry, my lord,
Filed by the petitioner and so who is under custody pending a trial in connection with write the case number.
Hello. Yes,
Police case is having no relevance now.
my lord, can we see my prayer portion, my lord, page 9? my lord? L,
SCL POXO
POXO,
pending trial in case of special POXO 179 within bracket H/2023. Before
before the special.
where do you
judge
get that?
Ujai.
For the special dash within bracket POXO Hojai. Course it was launched on the basis of an FIR registered as Doboka PS case number 141 of 2023. Section 366/376 within bracket 3 IPC Railway section 9/4. After completion of the investigation, the I'll search it. Full stop. The statement of the victim was also recorded under section. Here is the statements of the cases recorded under section 161 CRPC, as well as the statement of the victim 164 CRPC. Perusal of the aforesaid material. Aforesaid material are suggestive of the fact that the petitioner that the victim and the petitioner Rahmat Hussain
alias
Rahmat Hussain had an affair and on the insistence of said petitioner, accused him eloped with him. He further stated that subsequently Rahmat intimated her family members and accordingly her family member from the rescued her. Full stop. The witnesses of the other is that she was found in the Hojai market.
Doboka market.
Doboka market. Found in Doboka market. The medical evidence suggests that medical also suggests there is no injuries were found either in the body or private part of the victim. is on bail so as to early defend his case. Accordingly, the present application
Okay.
by 1000 order provided that the learned special judge shall party to a petitioner. While parting with the record, it is made clear that the observations made in the purpose of grant of bail under section as any comment merit of the case, comma, either of the prosecution or of the defense. Full stop. Disclosure.
Obliged.
None appears for the present application filed seeking transfer of maintenance allowance case number 2010 of 2000 pending in the Court of Additional Magistrate Nalbari to the Court of the Principal Judge Family Court Guwahati. As none appears for the petitioner, present applications for none. Yes.
May I please your lordship? This appeal, Lord. Is for the IA for.
I
Yeah.
I for bail.
Bail. 10 years. And 1 year, 1 year for 448 IPC. Housebreaking.
Here punishment 10 years under section 370. Section 1.
How many days you are behind?
11 months, 24 days.
What is the ground of seeking bail?
Your Honor,
What is the ground
as
of?
per the Azahar, the incident took place at on 16th of January, 2023. And nobody of neighborhood had any. Secondly, the accused is a neighbor, victim's brother's friend. As per the victim, he entered to her house by breaking the backside door. Nowhere, nobody stated that the backside door is broken. And also the investigating officer also not state anywhere that found. Then
Is not said. She said that he entered through backdoor road. It's
Yes.
not as a broken. Door may be open.
164, she has stated.
But where is your suggestion? Nothing is there. You have not challenged her statement during cross-examination. There can be matter of final hearing. We'll do the final hearing.
And a medical report also shows negative.
Report in these cases, there is an attempt. And there are some injury. It's not that there is no injury. There,
You're not only the brother is the witness.
no witness is required. When the victim is trustworthy, no witness is required. All. No. Learned counsel for the legal aid counsel. Legal aid sub entire matter may be taken up for instead of taking the matter be for hearing on 13th of June. To start. Connected ISNs to order to possible. Huh? Way of keeping all this. This can be ground of your final argument. Currently, her statement. There is no major discrepancies. Suggestion. I have stated so and so before IO. IO was not put that she has not stated all this. She has stated this. Nothing. Next case. Order kita, sir. Okay. Yes, Mr. Kamar.
Well, I have to appear because of the fact, my lord, that 5 times we have taken steps. But till now, I am told by my assisting counsel, my lord, that officers only given a note, my lord. Simple note, my lord.
Steps upon whom? What is the case?
It's a POXO case, so we have to make the informant or the victim as a
Okay, we are giving out steps.
But we have given the dates, my lord.
No, we have seen.
Neither the registry is, neither we have taken step through the PPO office. We have taken, but nothing is happening, my lord.
Yes, sir.
Yes, Madam, from Gograpar PS, Madam, 2 days time may be allowed, Madam. I will.
After tomorrow, Friday?
Yes, Friday.
Friday, okay. Kamal Lanet Senior submits that steps were duly taken and copy of the appeal memo was served taken for service of notice upon respondent number 2. Copy of the appeal memo was furnished in the office of the public prosecutor on 28/3/2024.
Oh.
on 18/4/2024 in terms of this court's order dated 28/3/2024. In view of such submission, the Borthakur Learned Counsel for Learned Additional Public Prosecutor submits that he will obtain instruction from the concerned IO as regards status of service of notice upon respondent number 2. Accordingly, he prays that matter may be listed on Friday next. Prayer is allowed, list accordingly. Or Monday, next Monday.
Let it be on Friday, my lord. We'll try Monday. He has already
You like to
himself
work on Fridays also.
Friday.
Nowadays,
Monday, well,
Friday.
Monday.
you have it, and if he has served it, you
Yes,
get
I
a
will, I'll get
WhatsApp
a report, my lord.
report, then
We can-
we will
Sure,
let
yes.
Please, your lordship.
Yes.
Your lordship, there is a delay of 22 days.
Kindly criminal appeal against judgment.
Judgment.
What is the punishment? This is under what provision?
138 NI Act.
128 NI. Full stop.
This will go.
Since it's NI Act, notice it, otherwise would have an application for continuation of 22 days in filing the connected criminal appeal assailing against the judgment and order dated 27/9/2023 passed by the learned additional chief judicial magistrate Kamat Hemaji in NI case number 23 of 2000. Returnable on, give a date after 4 weeks.
Obliged.
Steps. Any their party? No.
It is
Steps
not
to the
acceptable.
respondent both ways. That's in according. Yes.
Lordship, revision petition was converted to appeal, Lordship. Perhaps I need to make correction in the first title, Lordship. And secondly, Lordship, number of occasions we have taken we took steps, Lordship, on
Okay, this court under this order dated 12/1/2024 directed to convert the revision petition being criminal revision petition 425-2023 into an appeal. Accordingly, the criminal appeal number 20 of 2024 is registered. Now, what you do next? Learned counsel for the petitioner submits that he may be granted some time to correct the cost title of the present petition in view of the conversion of revision into an appeal. Prayer is allowed. Such cost title be corrected in terms of the extent norms prevailing. Full stop. Yes, Mr. Appeal has already been admitted. Now we have filed IA. Okay, we'll take up at 2.
अपना है ये अपन ये एक्स्ट्रा कॉपी अपन कॉपी
IA is for
Where is IA? IA?
54 years lady, my lord. Actually, it
What
was
is the-
convicted in absence of postmortem report. You did not collect the sample.
What is the affair? Allegation, how it started? Judgment, let us see.
Nine, my lord. I.
What basis you will consider? That's IA. What is the period of sentence?
On 20 January 2024.
4 years, man.
Huh?
4 years,
4
under
years.
section 314, man.
Huh?
314, man.
1-4.
Yes,
Okay.
man. Death caused by act done with intent to cause miscarriage, man. There are two parts.
How many days you
20 January. 139 days
when this appeal was admitted?
on last of April.
There is a specific order. It will be considered on receipt of LC.
Yes.
Okay. Down in IA. The present application is filed. Present petition is filed. Mr. G. Pathak. Suspension of sentence dated 20/1/2024 passed by the learned session judge, Kamrup Amingao in 126/ by enlarging the accused/applicant on bail. This court, under its order dated 24/4/2024, observed that prayer of suspension of sentence shall be considered after receipt of the LCR. The LCR has not been received. To issue reminder for the LCR and list this matter on next date we'll consider. After a week. Consider on that.
Taken as the last item, looks awaiting instruction. Looks. Same prayer, looks.
Last as after the list is over, we'll take.
May I submit? Lordship, this is most recent case, Lordship. Complaint filed on 29/2/2024, Lordship. And the present stage of the case is parents, because one of court is passing order for issuing someone NBW. The most
Has recovered from whom?
Page 11, Lordship may kindly see for.
Continue file an objection at
yes,
the
Lordship,
earliest.
Lordship.
How many days you are behind by?
In custody since 16/9/2020.
We'll do it next week. Next week. I file it then, so at least we can, in your absence also, you can take note of your things. Sir? MDECA, learned counsel appearing on behalf. You are also standing counsel?
No, on behalf of
On behalf of Mr. Learned standing. DRI, not NCB.
DRI, Lordship.
DRI. Press that granted a week's time. File an objection. There is allowed. List on next month, next Tuesday. Court has it. Wait for some time. Where? Yes, you just wait for some time. Let us to do the other. You see, it will be almost your part hearing.
Okay.
So let us do other cases.
I shall wait.
Both. both. These civil cases, these writ petitions will take after the other matters.
I shall also wait, my lord.
Yes.
My lord is regarding. Voting is for Quashing.
What is the 30? This is 13. What was the, what was,
14, if your lordship kindly. Item 14, my lord, that will be my lord.
item?
Item 14.
First, let us know what is the, what do you want? Please tell us.
Your lordship may kindly see.
Any application filed before the trial court? Or Jimma?
Yes, my lord.
Where is that order?
What? Last order is my lord at
Where is the FIR?
FIR is at lord. Page 21. No, my lord, page, no, my lord, page
Page 19.
17.
Page
17.
This is a forwarding. 17 is forwarding.
Yes.
Page 19 is
19
FIR.
is the FIR.
I'm correct. Where is your Jimma petition?
But the order I have entered. Twice,
It
my
is
lord,
very
because
vital.
earlier.
Very vital. Jimma petition is very vital. At what stage? When it is
Your
under,
lordship kindly see.
we'll come to that. Just let us clear. We'll hear you. Give a percentage. Under 7 of the new Act 2021, cattle prevention, there are certain procedures. Subsection 3, subsection more particular. And 4, 3, subsection 3 give a power to a specific officer to seize, apprehended or suspicion that certain offences under the Act is committed without any permission from magistrate. They can arrest, detain. So therefore, subsection 4 mandates that as early as possible, they will have to report it to the jurisdictional. And thereafter, under subsection 5 of section 11, a magistrate is empowered to give Jimma, even if prima facie case is made out. Exception is cattle. Jimma of cattle cannot be granted under subsection 5 of section 11. Others, even prima facie cases made out, can be granted. However, if Jimma is not granted, suppose you approach and not granted, an appeal lies under section 12.
But my lord, there is.
Oh, listen to us. Therefore, we want to know at what stage and under what circumstances you have preferred the application. If it is an application under subsection 5 of section 11, we'll wash our hands. If it is, and because there is no provision under the Act so far relating to disposal of property during inquiry and trial. So we have hold that this stringent condition of release is to facilitate investigation, and therefore section 5 conditions are given. However, in absence of any prescription under the Act so far relating to disposal of property during inquiry and trial, chapter 34 of the code will be applicable. Okay,
yes.
so therefore, you will have a right under section 451 or 457, as the case may be, to apply for a Jimma.
Vehicle and mobile phone, my lord.
Yes. So therefore, we want to know
Personal
what was the
vehicle.
application.
Personal vehicle, it's not cattle carrying vehicle, my lord.
Uh-huh.
Personal
No,
vehicle.
that we understand. It was alleged that offense was committed
Yes,
because
my lord.
beef
That
was
is-
taken.
That is where it is wrong, my lord. The FIR itself is a false
I'm
FIR.
asking you
bogus.
something. The question is,
Because, my lord, the catalogue, it speaks about live cattle. Is carrying cattle or selling beef meat.
see, this
Two
act,
things.
subject to what you say, this act is enacted for protection of cattle, protection and preservation. And the legislature in his wisdom has prescribed 3 ways to protect. One is restriction in transportation, and other is slaughter, basically these two. So there is a restriction of transportation except certain cases when you take it to a field, when you take it to the market, and there are special provision as regards the bordering district, so that there is no export.
Okay.
And there is a ban of sale of slaughter and sale of meat, beef, more particularly beef, except with a written permission. So therefore,
Yes.
and power to seize is given when there is any suspicion or there is an actually commission of an offense under this act involving any vehicle, convenience, or the cattle. That is under subsection 3 and 4. So here in your case, their allegation is that you have committed an offense. The vehicle was involved in commission of an offense under section under the Act 2021. Therefore, they have seized it in exercise of power under section 11. Now, thereafter, they might have reported in terms of section 4. That is where the question comes, when, at what stage you have filed the application? Under subsection
May I
5
submit, my lord?
or?
May I submit, my lord?
Yes.
Totally, my lord, because we are under it's a cold storage is, my lord, and minus degree carrying, my lord, goods from the factory.
These are facts.
My lord, facts, that is on record.
So these are facts on record.
Yes, ma'am.
Yes.
Because the cold storage under act, my lord. Section
So far that relates
Then
to
they have to go to that to verify, and they have to report to the food inspector. And then, my lord, food analysis will
that
take the
relates
sample.
as per determination whether it is beef or it is
Exactly.
is
Because we
buffalo.
have not packet. We have not packet. The factory, sorry. The factory, my lord, that is in, my lord, that Bihar Kishanganj. They have processed, they have got a valid license to slaughter buffalo and, my lord, package of buffalo meat. If any doubt arises, then they have to report to the food inspector of relevant, my lord, jurisdiction. They have to, the food analysis will, my lord, as per the act, food analyst will take the sample and examine in a manner government approved laboratory, which is specially for the food analysis. That has not been done. In anything, my lord, a doubt arises that it is not a beef, it is not a buffalo, it is a beef. Buffalo is not a banned meat, my lord, in India. That's why, my lord, the license is given to the factory for slaughtering of buffalo. And if somebody is carrying from that, my lord, factory, the police has to go to that factory for examination. They cannot carrying the, my lord, they cannot catch somebody in the way that you have carrying this, that, because they have to go to the roots, the who has packaged. Then they have to procure the packet and give to the laboratory for examination. So without examination, how can they see? Because we have not packeted, that is sure. The packets are not made in the way or some that valid factory, having valid factory license from the government of India, they are packeting. So if any doubt arises, they have to go through that. They cannot punish us on the way. They can ask because it is GST bill and everything is, my lord, there for carrying. It's not, my lord, somebody is carrying in a thela or in a vehicle or somewhere, because there is no question of live cattle, number one. Number two, if the meat is, my lord, doubted, because in each and every packet, I've given color photograph of the meat. That is, my lord, processed meat, and my lord, it's in frozen condition, it is carrying -6 to 10 degrees. So, my lord, the package, my lord, meat, if any doubt arises, those who are packaging, then you have to go to them. The police has to go to them and, my lord, request the food inspector of that particular area to seize the meat, or, my lord, the food analysis will, my lord, examine it, and then, my lord, a case can be made out. But not against us, because we are carrying only.
Provision of law.
Provision, they are, my lord, carrying, they are doubting that, my lord, carrying beef meat.
Investigation
On what
may
basis?
starts on doubt
Yes.
also.
On what
But we
basis? they
doubt
can-
this package
Yes, my
to
lord.
be brown sugar.
On what
We
basis?
seize it, then we send it to forensic. Forensics report may come, no, this is not
They
a
have
brown
to-
sugar or it's a brown
Yes,
sugar.
my lord, they cannot register a case under Cattle Act, because the processed meat is having all, my lord, particulars in the packet. So they have to take the packet, and the manufacturer who is packeting, they have to go to them. And, my lord, making allegation, false allegation,
Relating to the
violation of Article 40. They cannot
vehicle. A vehicle. Huh?
minus degree refrigerated truck.
Vehicle. For us, it's a vehicle. A vehicle is seized.
Yes.
Under what provision? Connection with the case registered.
Registered under Cattle Act, my lord.
They allege that they have reason to believe and suspicion that these are carried out or there is a violation of Act of 2021.
All other act will not come when we are protected by the punishment is
Yes,
also
yes.
under FSSAI Act. Punishment also under FSSAI Act, and, my lord, the testing and other, my lord, protection is under FSSAI Act. When we are covered, we are having license of FSSAI. They cannot impose this, that.
Let us now
other food-
keep aside
other
this
food.
Jimma. Now let us go to the Quashing then.
Have prepared a written argument also for your
We'll go to the
lordship.
written argument later on. Let us understand the facts.
Here also same FIR, my lord. I'd like to place the law first, my lord.
Let us understand the facts first.
Read the FIR, my lord, now.
Yes.
25, my lord. I have the honor to inform you that on 29/11/2023 at 5 p.m. received information by IC Simo outpost from a secret source that vehicle bearing number so-and-so, the name of Buffalo meat from West Bengal side to Guwahati. Accordingly, the information entered in the GDA file above reference GDA number IC Simul post asked me to conduct NACA checking. Accordingly, I have conducted NACA checking, and after 1 hour, I found the vehicle loaded with buffalo meat as per e-way bill and tax invoice produced by the driver. On asking, the driver said he loaded the meat from Kishanganj, Bihar, but in papers it was found from enterprise Khanapara, Guwahati. As suspicion exists, the matter was informed to superior officer of police, who asked to verify the same with veterinary department, and accordingly SDVO Gosaigaon to verify and send Mr. Sidar Zahidur Islam physically verified, told the meat may be beef, maybe, my lord, may for further confirmation, the meat should be sent to Directorate of Forensic, Kailipara, Guwahati. Then again, same inform to superior officer who asked to send the same to Directorate of Forensic Science and Laboratory, Kailipara, Guwahati, and as the items are perishable in nature, seizing the same be left in Zimma to the driver itself with a submit to their destination as mentioned in the papers that is Eden Cold Storage. Have seized the same and randomly sample drawn the presence of a veterinary official and sent the sample to the expert opinion from Director of Forensic Science and Laboratory, Kailipara, Guwahati, which opined that the meat.
Where is your case diary?
Yes, well, case diary is available.
Further, it has been learned that the owner of the so beef in Guwahati area since long knowing for selling the Hindu people decided. Again, he very cleverly attacked the beef.
Just give the case diary.
So, my lord, that is the affair. My lord, that page 27, where from the meat was brought, my lord. Mass Agro Food Limited.
Case diary. Just wait for me.
Was also available on.
It was initially sent to the cold storage, still report had come.
Yes.
And thereafter,
Thereafter,
cold storage was also sealed.
yes, madam. There was passport desealing of that code.
They are not entitled to this, my lord, immovable property. Violating the law, they are.
Sheet not yet filed. It is pending here since long.
pending. Whatever, just enlighten us. What kind of authority granted to forensic science laboratory? What test they can do?
This case, my lord, your lordship has already gone through the, my lord, FIR, and your lordship has rightly pointed out various provisions of the, my lord, the present act regarding why object also, my lord, regarding.
That we understand.
That,
Everything
yes.
is clear.
But
No
here in
problem on
this
that.
case, my lord, what happened? Only basis of that FIR, later on, my lord, investigation going on, some samples collected in presence of the
Very
veterinary.
well, no problem up
Yes,
to that.
yes, in,
Doubt certain things to be
yes,
beef, which is barred in transportation.
under section 8 of the, my lord,
Yes, there is a bar in
in
selling
any
and
form,
transportation in
beef and
without
beef products
without
in
a
any-
certificate under the act.
Yes,
That we understand.
yes.
So there may be genuine apprehension that this is actually if not buffalo meat.
Yes.
No problem up to that. Up to that, fine. But who admittedly these were transported under e-way bill from a manufacturer? Because only transportation. Transportation is also bad. Very well. Destination is Guwahati, Assam. So therefore, no problem on that. You can do it. But where is the authority of forensic science laboratory to even determine whether it is beef, processed beef, fresh beef or buffalo?
But now in this case,
No,
what-
just answer me.
yes, I will point out, my lord. Here in this, there is no specific provision in the act that, my lord, at what stage and what materials has to be sent to the, my lord, forensic science
No,
laboratory.
there cannot be.
Yes.
There
that-
cannot be.
But here, while, my lord, police suspects on the basis of, because initially from the secret information entire, my lord, initially.
No problem on that.
Yes,
You have every right to suspect.
yes,
No problem on that. You have
Yes.
every right to suspect. You have every right to start investigation. You have every right to taste a material or a beef, whether it is beef or buffalo. Up to that, no problem. Where is the forensics authority to do so? So as that will say that this is the procedure they have done, this is the result.
now, my lord, regarding the what authority, the forensic, my lord, how they deal with all these, my lord, materials, that is difficult for me to answer. Because, my lord, here,
No, you are representing the prosecution.
yes,
Because prosecution is convinced
yes,
that forensic is having the authority, so therefore they have sent buffalo meat to be tested by forensic.
because, my lord, in all
And
other,
admittedly, this is a food packaged and declared to be a packaged food
yes,
under frozen condition from a manufacturer. There is no doubt from your case diary. That is what I have seen. There is no doubt about that. So when it is declared to be a meat, they declares it to be meat, which is not banned. Transportation of which is also not banned. You suspect that no, this is not beef. This is not buffalo, this is beef. And therefore you have violated the provision under section 21. Okay. And it is admittedly packaged, all transportation, salons, entry salons, everything is seized. So therefore, what should have been the procedure? And if this procedure is violated, what will be the answer?
lord, it cannot be said that procedure has been violated. Because, my lord, why I am saying so?
No,
Because-
therefore, we'll have to understand.
Yes, my lord, because
To
in,
come into a conclusion that procedure is not violated,
Yes.
we must know what the procedure is.
because.
You
my
are
lord-
saying I am not aware.
Yes. No, I'm saying because, my lord, regarding that your lordship has initially asked, my lord, regarding what is the procedure followed by the, my lord, forensic science laboratory. Regarding that, my lord, I am just, but regarding the prosecution in all other cases, my lord, what happened in NDPS case, in all other cases regarding if sample collected, then where from police will get to know that this is a particular, my lord, substance is a, my lord, any, my lord.
What I am asking, I
So
want to know
here, my
that.
lord, what to depend? Police prosecution agency will have to depend on the forensic laboratory. Because that is the, my lord,
Police will
authority.
depend upon the forensics laboratory unless and until there is other prescription. If there is a other prescription of law saying that this is to be tested in this manner,
Because my lord, your lord,
your
just
whole
now-
basis is it says cow antigen.
Yes.
Do you know what is cow antigen? Cow antigen may be in the buffalo also. They are of same species. It is antigen, antibody.
Because my lord, yes, antigen, antibody, but cow antigen cannot be my lord buffalo antigen. That only can be determined by the forensic laboratory. And here forensic laboratory specifically said that this is an my lord, antigen of cow.
Therefore, we want
So, my lord,
you
this
to
is-
enlighten us on that. Because this is a processed food and there is a procedure laid down on
yes.
under Food Act.
I understand your lordship may pointing out towards my lord FSSAI Act, my lord.
Ah,
But FSSAI Act, my lord, that is on regarding the quality of the food product. But look, here in this case, the police is not regarding the quality of the food product because there is a specific ban under Section 8B for any kind of beef product.
that
So
is why we want
that
to
may
know,
be
that is
packaged
why
or
we
in any other
want, see,
form.
this is your case.
Yes, my lord.
This is your case. So we want to know the expertise of forensic determining the what is this is a beef or buffalo. We want to know that. If they are having the power and FSSAI is relating to food, we may wash off our hands.
I think that your lordship may allow some time and I will go through in my lord more
They have
detail
to.
regarding that.
They can give a call to the.
No, that
to a
call
food
will not
inspector, that
give
is the
me
laboratory is
any
in my lord
answer.
Bamuni Maidan. Not
Okay, you tell us,
all and
you
everything.
tell us your case.
all and if it's
You
I
show
my
us,
lord.
show the law. Facts we are
Yes, so
here.
that is-
For your lordship
done.
assistance, my lord, my friend has
Situated
provided
Bamuni Maidan,
one,
man.
some of the my
Government
lord
effort.
articles regarding my lord how, I am just only providing for your
That may
lordship
be
assistance.
anything that enlightens.
Then contact any of the food inspector, they would, the laboratory is not. Is in Bamuni Maidan, they are.
Okay,
food
anyway,
analyst,
this
food expert.
literature may help us sometimes. We
Yes,
are not. Okay, what is the act says?
Then I'll come to the facts, little bit facts I'm placing, my lord, give 2 minutes. So, my lord, page 27, here is the license of that factory by.
Understand, there is no doubt about that, that a product is sent from a manufacturer license authority. There is UA bill, vehicle is
my lord,
specially meant for
Slaughter,ing, my lord, a buffalo
transporting
also
this.
license,
And
yes.
this meat is declared to be buffalo meat in its packet by the manufacturer. There is no doubt about that. They also admit it. But they say this is actually, this is a fraud played upon the people, religious sentiment of the people, and this is actually not a buffalo. Now, show us your FSSAI Act. FSSAI Act. How many other methods are there? Take some time.
What? Page 5, my lord.
Just a minute, just a minute. What is the name? What is the name of the act?
Safety and Standard Act. Safety and Standard Act, 2006. Earlier, my lord, the current act, sir, my lord, prevailed. Covered everything, my lord, food, quality of food and all.
Okay. Which provision you want to?
My lord, what is the food? Food means, which this cover will, act will cover, my lord.
Section
And my lord,
3J.
say.
Hmm.
Whether processed, partially processed or unprocessed, which is intended for human consumption. Primary food to the extent defined in clause J and or engineered ingredients, infant food, packaged drinking water, alcoholic drink, chewing gum, and substance, including water, used in the food during its preparation or treatment, but does not include any animal, live animals, unless they are prepared or processed for placing the market for human consumption. Harvesting, drugs and medical products. Food analysis. That my lord, my lord. Food analysis means an analysis appointed under section 45. Laboratory. Laboratory means any food laboratory or institute established by the central or state or any other agency or accredited by National ASN Board for testing and laboratories or an equivalent accreditation agency and recognized by the Food Authority. That's section 43. Party, it is Kamuni Moidan, my lord. Laboratory is there, my lord. Kamuni Moidan. Safety means assurance that food is acceptable for human consumption according to its intended. Next is page 7 of my lord. Or adoption or any conversion of ingredients, article of food which includes any sub-process incidental or ancillary to the page 37, section 30. Examine it.
Examine what?
Examine anything, my lord, any food.
Not anything. What is the jurisdiction?
Section.
What is their purpose? Come to section 16.
And functions of food authority. Shall be the duty of the food authority to regulate the manufacturer process as to ensure.
So this object is to monitor
Yes.
safe and
Sale and import of
safe sale and import of food. And what are the provisions that are treated to be an offenses?
time to time they visit and my lord. Time
But
to time.
we need to do what? See that this is not
take
beef, this
samples,
is
my lord. They take
this is
samples.
buffalo.
They take sample and my lord.
Why they take sample?
Examination.
Examination
Visit,
to
my
do
lord,
what? What
visit-
is their
regular
authority?
Visit is there.
Their authority is to see that whether food is safe or not. Okay. Now to see that
Manufacturer, particularly menu.
and
Current.
if you can go through section 18, it says everything.
Administration of act.
Ah.
How to.
So
my lord,
what is the object
how
of
to
that?
end
What to
of
be
this
done
act?
is given
Yes.
there. Now, if you come to section 19, chapter 4, that is the general provision as regards the safety of the acts, the foods. What it says? Contamination, toxic substance, heavy metals, pesticide, veterinary drugs, residues, antibiotic residues, microbiological residues, genetically modified foods, organic foods, functional foods, proprietary foods.
For
So
testing and
these
answer in
are
laboratory.
the authority of a laboratory to look into whether there is contamination, whether there is pesticide, antibiotics left. All these are.
All details.
So their argument is that whether it is beef or buffalo is not the subject matter, cannot be the subject matter of this,
Forensic laboratory.
or cannot be subject matter of food safety laboratories, because they will see whether antibiotics are there. whether some toxic contaminants are there. So then, therefore, I ask you that the first, what are the offenses alleged? Can you quash on the basis that really this was not beef, it was buffalo? Can we make that determination in a application under 482 on the basis of that?
Which act will be applicable? Whether the cattle act will be applicable or FSSAI will be applicable? That is the answer, my lord. Because
Prima facie, we are viewed that
license-
FSSAI is not
since
applicable.
we are having license under the
If
FSSAI,
allegation would have
FSSAI
been,
will be
if
applicable.
allegation would have been that this is a contaminated meat you are selling in the market, then FSSAI would have come. If it is a thing that this is a genetically modified meat you have not disclosed, then it would have been FSSAI. That antibiotic remains, then it would have been an FSSAI.
That examination has to be done in the manufacturer. from the
Allegation is not
manufacturer.
that. Allegation is that you have used buffalo meat, declared a buffalo meat, beef to be buffalo meat.
A responsible person. It
Yes,
is
we
not, my
understand
lord,
that is a matter
act
of
they are
trial,
getting
not
license
a
under- from the
case of
government of India.
cost-man.
Is
This is not a case of cost-man. We can consider the
similar cases, my lord, Pepsi and my lord here silver double
Pepsi,
yes,
Pepsi and Silver drop is that you declare there is no sugar, Diet Coke, but it contains so much of milligram of sugars. They will go say Patanjali. They say that this is so and so, so and so. FSSAI laboratory says no, this is not that, that is that. Then that offenses will come under that act.
the FSSAI act be applicable if they are having any doubt. And
Any doubt?
storing.
Therefore, I have asked
Now,
you the
they have
section
to go to
18.
the manufacturer. They have to go to the manufacturer, or they have to, with the help of here also when our food inspectors are there.
Your allegation
have
is
to
not
test-
as regards the quality of the meat. Your
Quality
allegation is
no.
not against the
no,
quality
my
of
lord,
the
it
meat.
to
They
de-
say
no, my
that
lord,
this is
it
a
has to-
fraud.
It has to determine whether buffalo or beef. Whether buffalo or beef will, laboratory only can test and declare it.
But
Police
what
cannot-
is
police
seen
cannot-
in the, now let us see the FSSAI laboratory, which provisions you want to rely on?
Food inspector, they have not gone through.
No,
Right.
that will come. First, we decide that to determine that whether meat is of a certain animal is vested on the FSSAI, then of course, that is what we are not getting.
Processed meat comes under FSSAI.
Processed meat come under, food comes under SSSI.
But food, my lord, any processed food. It's a food. Processed food.
Processed food, it
Processed
comes under
FSSAI.
FSSAI.
So
And
FSSAI
FSSAI's
approved
jurisdiction is so far relating to the quality of food.
all aspect is valid.
Where is that SWAS? I want to say, go through it. Because I have shown you the chapters 18, 19. It wants some
Then
time
it's
to
not
come
defining
prepared,
us.
then
It is, my lord, let me give. I'm reading again, my lord. 18, I'm reading. Central government, the state government, the food authority and others agencies, as the case may be, while implementing the provision of this act, shall be guided by the following principles, namely, endeavor to achieve an appropriate level of protection of human life and health and the protection of consumers' interests, including fair practice, all kinds of food trade with reference to food safety standard and practice.
safety standard and practice. Now come to other chapters, 18, 19.
Area of risk management.
So
Whether
19
what
comes, general provisions as to the articles of food.
For the purpose of this section, processing or including a
No articles of food shall contain any food additive or processing aid unless it is accordance with the provisions of this act. So
Other
this
with-
can be a violation which
other-
can be tested. Now come to 20. Contaminants necessarily occurring toxic substances, heavy metals. Now come to 21. Pesticides, veterinary drugs residues, antibiotic residues, and microbiological counts. This will be tested if allegation is there.
The 22, my lord, I'm reading.
Yes, genetically modified foods, organic foods, functional foods, proprietary foods, etc.
Section
Because
22
all
I'm
what
reading.
should be the standards are regulated under a delegated legislation, which is rules.
Who will say? It is buffalo or my lord cow? Who will say? Beef or buffalo?
They are saying
Who will
that
say?
this is forensic can say
No,
until
my-
and unless
no,
you can
no,
show
no,
that
no, no,
forensic
only
is
food.
not having
No, my
expertise.
lord, what is the use of this act, my lord, then?
Use of the act
Because-
is to protect food and its safety.
Exactly, my lord. If they are doubting that we are
So this is not a
selling-
question of safety. This meat may be safe for human consumption. If it's being
only
taken
that
by
area, my lord,
some people,
not only that area, it my lord covers everything.
no,
Whether
it cannot.
anybody is my lord selling.
Show us. That is what I'm
manufacturer-
asking you. Show us that it
Yes,
covers
my lord,
everything.
I'm coming, your lordship, that I'm coming. That section 22, genetically modified food, organic food, save as otherwise provided under this act and regulations made thereunder, no person shall distribute, sell or import any novel food, genetically modified articles of food, irradiated food, organic foods, food or special dietary use, functional food, health supplements, dietary foods and such other
Certain
articles of
foods
food
are
which by
permissible,
central government may
genetical
notify
modified
the
foods are not permissible. Therefore, that is an authority advisory board is constituted. The rules are formed to look into that. The manufacturers are not manufacturing, distributing and transporting these foods which are having contaminants, naturally occurring toxic substance, heavy metals, pesticide, veterinary drugs residues, antibiotic residues. You may say it covers everything,
That does
but
not
it will
include
have to show us. We are open to ideas, no problem on that.
that Food Safety Act were covered under is also required to be authority.
Suppose
So,
it
my
is their allegation that your food brought from UP to Guwahati contains antibiotic residues. If they allege that, of course, FSSAI. But if they allege that you have fraudulently declared and transporting beef in the name of buffalo, I have serious doubt that it will come under food safety.
people are not blind, my lord. In the packet, what is written?
That
My
is,
lord, it is a
that is fine.
buffalo.
They say. We are not saying. They say. This is the allegation.
Buffalo is eating.
So they were to verify that they send it to a forensic. Forensic say there is having cow antigen, therefore this is a cow meat. That is a subject matter of trial, whether they are having the
The
authority.
police can take the sample first.
Lord, whether those
Police
Section
cannot
45.
take the sample.
Yes, my lord.
Police cannot take the
Police cannot
sample when the allegation is under FSSAI. There is no doubt about that.
So it's a
Us,
frozen
therefore,
food.
let us have a
It is a
satisfaction that
frozen-
this is come under FSSAI.
It's the frozen food. And my lord, police, it is not a cow, live cow. He will take
No, no, come to section 8 of the Act.
it. Yes, but my lord, this is packet, my lord. This package, there is no package meat talking. 8. This, my lord,
See, meat, beef.
beef. Yes, but my lord,
But
live cattle,
normally,
that is-
madam,
that
see,
is the
we'll have
different
to, you will have to
Application of this
argue a
act.
case within the legal parameter.
legal parameter, my lord.
That is the legal, the fundamental is whether this is a case under FSSAI or section 21. Whatever you are saying is FSSAI. Even then, if you can satisfy this
45.
court, that whole FSSAI Act will be applicable when it is alleged, allegation is made, and accordingly, it is the only FSSAI authority who is empowered to take the sample,
Sample.
not the forensic. You show us from that we are squashing this, that you have committed mistake.
Please, my lord, section 45, I want to.
You come prepared.
Section 45.
I'm
my lord.
better prepared than you. That is the difficulty. So you come prepare
At least,
better than me.
at least allow me to read the written argument. I have everything like that here.
You want to conclude it today?
Like, I'll be fixing, my lord, because already 6 months have gone. Neither this, my mobile. phone
Vehicle, we
phone-
don't have any difficulty. But we have asked certain question to release your vehicle that you have not answered. We have said at what stage application was filed.
My lord, vehicle carrying cattle, my lord, that can be, my lord, they taken Jimma, but vehicle not carrying either cattle or my lord, the personal
Oh,
vehicle.
no,
taken from Guwahati.
vehicle can be granted Jimma by the magistrate under subsection 5 of section 11 when even a prima facie case is made out, but except cattle.
But in fact, order for releasing the vehicle has already been passed. But only that, my lord, that regarding the, my lord, the.
Bank guarantee.
Yes, my lord. that
Bank guarantee part, therefore, we have held that question of bank guarantee will not come at the stage of chapter 34. A stringent condition cannot be made applicable at the stage of 34, chapter 34.
The
Of
written
course,
argument?
when it is produced, you immediately go and file. We'll have to interpret it that way. Otherwise, that stringent provision cannot be. So what is your application? That is what I have asked first. That application is not part of your petition.
Because my lord, twice revision is first, my lord, they have then I filed the first revision, then order was passed, my lord, by the honor court. And my lord, there the cold storage was asked to release, my lord. But my lord, it was again sent back to the my lord at court below. All
No, madam, to release the vehicle, we want to know where is your application? Having a copy of that.
And the lower court not enclose this. I have not enclosed it, I have enclosed the order.
Because they are raising a point that if an order passed under subsection 5 of section 11 is an appealable order under 12. We will have to negate their argument and say that no, this is an application under chapter 34 under 451 or 457. as
To understand, my lord, why the FSSAI Act is not applicable.
Okay, we'll forget the Jimma. You argue on this. Okay. Yes.
Why the my lord, FSSAI Act is not applicable? That is, I fail to understand my.
No, that is not the issue. Issue is you will have to what you fail to understand is not our subject matter. What our issue is that you will have to satisfy that FSSAI is applicable. We have asked certain question. You will have to answer it. We will be satisfied. We will set aside cause the entire proceeding. You have argued certain things. So now we will not.
My lord, section 45.
You then we will not interact. Yes. Which provision you want to say? Tell us.
Section 45.
Yes.
And my lord, first petition 37, my lord, earlier was section 37 and my lord 37. The Commissioner of Food Safety shall by notification appoint such persons as he thinks fit, having the qualification prescribed.
Yes.
37, my lord.
Section 37. Yes.
Commissioner of Food Safety shall by notification appoint such person as he thinks having the qualification prescribed by the central government as food safety officers for such.
Let us go together. Let us first go to the object of this act. First page. The Food Safety Act 34 of 2000, an act. Just read that. An act. Have you got it?
An act to consolidate the laws relating to food and to establish the Food Safety and Standards Authority of India for laying down science-based standards for articles of food and their manufacturer, storage, distribution, sale, and import, for availability of safe and wholesome for human consumption and for others connected herewith or incidental thereto.
So this is the object.
This is the object.
So
my
what
lord,
is the object? Let us
somebody
understand.
is sitting, my lord, to sell beef by actually buffalo meat, selling, my lord, that is the beef. That is also my.
Is basically
that is
food
also
safety
sitting.
and standard. Nobody is saying that this is not safe food or it is not fit for human consumption.
No, it will not be
They
safe.
are saying that this
Somebody
is
is selling, my lord, beef. Selling, my lord, it is a buffalo meat.
That may be cheating, that may be forgery, but this is not a question of safety and standard.
Safety, my lord, because we are not having beef.
Okay.
If my lord, instead of beef, my lord, not having beef, instead of buffalo, if somebody is selling my lord beef, that also, my lord, that has to be careful, because all food, my lord, milk, we eat. Milk is also, my lord, covered, because milk, my lord, different milk sells. If actual milk is not there, my lord, then act will cover. There also, my lord, the allegation is, my lord, that beef. My lord, actually, they are selling buffalo.
Now come to, you are arguing that, now come to subsection Q of section 3. Read it.
Safety
Yes,
means
read it.
assurance that food is acceptable for human consumption according to its intended use. Intended use, my lord. Somebody is selling beef, telling that, my lord, again my question, my lord, buffalo. Then also, my lord, it will come. One cannot, my lord, sit the public health also and my lord, sitting. People are not taking beef. But somebody is telling, my lord, misrepresenting that.
What do you mean by intended use?
Use.
Here it says food safety means assurance that food is acceptable for human consumption according to its intended use. Intended use may be, suppose some food are there, tin fish is intended to eat without cooking. This is intended to eat. Use is intended to eat, is a raw meat.
Use. Yes, my lord, that I'm giving a simple examination that I'm intending to have potato chips. If it is a not potato chips, but it is a RB chips, then my lord, that is also sitting, my lord. Not only sitting, my lord, that
Don't bring the sitting here. Sitting will not come.
But my lord, intended, my lord, I want to have, my lord, this kind of food. But my lord, people are selling cornet food. Then also that intended use. What I understand. Fail to understand, my lord, give me time.
That is what we are saying.
If you, because
We have no problem if you
my
proceed,
line of
we'll
argument
proceed,
was
we'll
different.
decide. Book is there. We are only here to decide.
My line of argument was different. Since having the act has made to punish or protect the food industries under this act, either punish or protect. My lord, the protection is, my lord, the not having authority to
Absolutely not. Absolutely not. Police is
pick
not
up the
having
processed
authority
food.
when it is allegation or commission of act or offences.
Yes, my lord.
And as described section 18 and 19. This is not the case here. That is why I'm saying, if you say that everything will be covered, you just satisfy us, everything will cover, we'll pass orders. Our idea is open, but you'll have to satisfy us. Then otherwise we will go by our
Argument was different because the food safety officer, food analyst, and approved laboratories, they have the authority.
They are not doubting that this is not food.
They have the authority.
They are not
All
doubting
these
this is
has
not
been
food or
violated.
this is unsafe food. What they are saying is that you have transporting a banned meat in the name of a meat which is actually not banned. That is the allegation.
That is the allegation. So, my lord,
in
that
that
will
context,
also-
you'll have to satisfy us that Food Safety Act is applicable. That's why I have asked it, what is the meaning of the food safety?
they have followed is not CRPC.
That is the issue.
That is the issue. Whether CRPC will apply or, my lord, the
CRPC will not apply when you say that in the backdrop of the present case, where it is alleged that a banned meat is being transported in the name of a non-banned meat, whether Food Safety Act will come. If Food Safety Act comes, it comes, you will have to satisfy that. Primarily, we are not yet satisfied. That's why these
Okay, my
questions
lord,
are being
let
put.
me study more.
Moment we are satisfied, it will not take 2
tomorrow,
minutes.
my lord. Thursday, my lord,
Thursday.
Thursday.
Whatever, be ready. Don't think that you will have to show us that where is the authority of the forensic declare
That
an
I'll also
antigen
get some.
of declare some meet of some animals on the basis of an antigen. What is the technology you are using? We will ask this question. Be careful.
Details of the food laboratories, my lord.
Don't think that
And
we have
then
taken
I'll
any
come
view.
with
All
it.
these are questions that are coming.
Don't give it to the part head, my lord. Thursday fixed. one.
Thursday we have fixed it. Your all arguments as regards procedure of FSSAI will come later on. First, you'll have to satisfy that this is applicable. Moment it is applicable, we'll come to the procedure and we'll see the procedural lapse. When
Sure.
there is,
I'll
when we,
satisfy on Thursday, my lord.
on the prayer of the learned council. And go through the act.
Yes, I'll go through.
Go
that.
through the act properly. What is the object? I'm also asking, what is the object? What are the things that has been barred under this act? And what is the authority of that advisory board and the laboratories, and to what extent?
Go through it.
Judges are better prepared than lawyers. That is the difference. Therefore, lawyers will not be happy. The judge takes a view, and this is bad for the judge.
Something. Idea.
Oh, that should be pointed out by the lawyers, not by the judges.
Sometimes my lord, we miss it. Lordship points out, we should look into it.
That is correct, but still, yes, next case. Yes, Mr. Chaudhary. Any IA?
Yes, my lord. Here, my lord, what has happened, my lord?
Heard Mr. Counsel for the petition. The present appeal is preferred against
Judgment and order dated.
Judgment and order dated 34/24, my lord.
order dated, just a minute.
First page, my lord.
Judgment and order dated 34/2024 passed by learned special judge CBI Assam. Learned special judge, additional court number 3 Assam. In special case number 40 of 2008. Convicting and Silva sentencing.
My lord.
Peruse the judgment, admit, call for the records, issue notice. Anybody, any private party? No. As Mr. Swenso accepts notice, formal notice need be. Copies
Yes,
be furnished. What is the sentence?
2.5.
Art, Mr. An application 89(3) of RPC for suspension of sentence passed in connection with Swenso's. So, peruse the statements made in the application on the sentence, considering that there is no immediate likelihood of taking hearing. The judgment impugn sentence, the suspended. Previous bill?
Yes.
Okay. Yes, bill. I stands this for.
Highly obliged, my lord. Obliged.
LCR may be called. Paper book will be required, I think.
We'll see. Let the LCR come. Yes, what is this?
The petition has been filed for quashing of the charge sheet, my lord, who are the petitioner, my lord.
Motion or
what-
admission?
Yes. Why? Because I say, because originally,
Now what to be done today?
well, it has come up for admission, my lord.
Let her remove the gown. Heard Mr. J. Kamar, learned petitioner. Learned senior counsel for the petition, assisted by
Naam to call.
under section 482 CRPC or quashing the criminal proceeding in PRC case number 822/2020 arising out of all women PS case number 30 of 2024. Section 294/506/350 IPC.
Well, now it will be charge sheet dated.
And in the meantime, a charge sheet has been filed being charge sheet number 02 of 2024 dated 30/1/2024.
Under 160 IPC, my lord.
Under
160
section
IPC.
160 IPC. Good stuff.
Next page.
The informant, present petitioner was the informant
Yes.
in police station case
Yes, my
number.
lord. The same case, my lord. PRC.
In
All women
all women
PS case
PS case
number
number
3.
03 of 2024,
Oh.
which was initially registered under section 294/506/352 IPC. Full stop. However, while filing the charge sheet, the investigating officers had arrayed the informant as an accused, as an co-accused,
Yes.
along with
The main accused.
the accused,
FIR named accused. sorry.
along with the FIR name accused. And offenses under section 161 IPC
Right.
has been registered. Full stop. This matter needs further consideration in as much as the legal issue will remain whether an informant can be joined as an accused along with the FIR name accused. Full stop. Considering the number of allegations and the nature of charge sheet, this court is of the view that further proceeding of
Of the
PRC case number
PRC case number.
822/2024 shall be suspended, ordered accordingly.
Date probably
Shall be stayed,
suspended.
shall be stayed, ordered accordingly. But what happened, await the service report in respect of respondent number 2.
IO होगी. Much.
Mr. Nath, let us just complete the criminal measure. Jumping here and there is a level.
Time permits or
We'll try our level.
Lordship, no problem from my side, my lord.
Yes. Item
40, my lord.
0. Ten copies received. 10 copies received.
One copy received, my lord.
None appears for the petition. Mr. Present revision petition is filed. Filing an order dated 9/1/2020. Order.
Page 58, 59, madam.
Yes.
58 of the petition, madam. 58, 59.
Dated 9/1/2020. Asked by the learned additional chief judicial magistrate Lakhimpur, not Lakhimpur, whereby the prayer of adjournment made by the accused, prayer for adjournment made by accused was rejected, and cross-examination of PW1, namely Bhuban Chandra Das, was against it. FIR protocol. The prosecution was launched on the basis of an FIR is there.
Where is at page 18, madam, Annex 3.
On the basis of an FIR, wherein it was alleged that Borana
Bora and madam. Three petitioners, madam.
three petitioners, na?
Yes, Gulab Bora, Zuti Bora, and
Person has come, his allegation is against his wife.
there, my lord, that my lord, cross-examination was dispensed with. And there, against that order, my lord, petitioner approached before this.
First, the impugn order reflects that on 9/1/2020, PW, PW Sri Bhuban Chandra Bhuya was present before the trial court make his deposition. However, a petition being petition number 167 was filed by the present petitioner, isn't it? On behalf of the present petitioners, praying for an adjournment on the ground that their learned engaged counsel had sustained fracture on his head, leg, and chest, due to which the learned engaged counsel was not able to appear before this court. Full stop. Accordingly, an adjournment was sought for. Full stop. However, the learned magistrate has rejected such player that no supporting medical documents has been annexed with the such application. And also for the reason that the matter has been pending since the year 2002. Now it's difficult whether he is alive.
Regarding the present stage of the
73. But case has not progressed. Thereafter, your IO has not appeared for till now. Is there? If he's there, if he's not there, that should not be our lookout. This court all for the case scan copies of the case record which has been from the case record is seen that the trial is still at phase of examination of the prosecution witnesses. What I was just go through it, how many witnesses are examined?
yes.
According to what I could understand is except that nobody has been examined till now. There is no stay.
Is the order of 2020.
Order of 2020, there is no stay, but it on the record further reveals that the IO has not yet appeared before the has not yet appeared before the trial court to depose. In the meantime, non-bailable warrant of arrest has also been issued. And other witnesses are all not yet examined. Full stop. The fact also remains that the ground seeking adjournment, in the considered opinion of this court, was a genuine ground, in as much as it was an emergent nature, as according to the petitioner, their lawyer got injured and got fractured on the day itself. Full stop. Considering the aforesaid and also considering that that other witnesses are yet to be examined, this court is of the view that the accused petitioner shall be granted a chance to cross-examine the PW1. Full stop. Accordingly, the impugned order at so is set aside and it is provided that the learned trial court shall fix a date for cross-examination. Learned trial court shall recall the PW, namely so for cross-examination, revision petitions. A copy of the order be forwarded to the
Please, Your Lordship. Lord, I have come, my Lord, seeking quashment of the charge sheet vis-a-vis the process of PRC.
10 copies. Or have you gone through it? Yes, what is your ground?
Lord, the FIR, my Lord, which my Lordship will find at page 20. There are 3 numbers of accused person, my Lord. I read, my Lord, Assamese vernacular, my Lord. বিনীত নিবেদন এই যে যোৱা 6/12/2018 তাৰিখে গধূলি প্ৰায় 7 মান বজাত 2 নং 3 নং পদকীয়া নেতৃত্বত 3 নং পদকীয়া মিলত
Just a minute. Representing the accused, informant, a party.
Process is complete, but no one is appearing, my lord.
Let us see that. Is there any stay? Notice.
By the council.
Why warrant? There is no stay.
Particular person, my lord? One, my lord.
That we understand. Your name is?
I am Kuthal Begu, my lord. Lord also, my lord. About my lord him.
Heard. Mr. Learned Council. Yes, Bhattakur.
Yes, my lord.
In the 164.
Court also, my lord. Hymen is intact, my lord.
It will rhetorical record. No, forget about. She is not supporting 164.
164.
Helped her, my lord.
What is your name?
Kuthal Begu, my lord.
Probably, my lord, in view of 164 statement, but later on, my lord, search.
Heard. Mr. Das MK Das Learned Council for the present application 482 of the filed for setting aside / quashing charge sheet being CS number 143/021.
My lordship.
2021, dated 29/6/2022. And the resultant prosecution being PR case number 198 of 2021, arising out of GR case number 1203/2018 within bracket capital SLP, registered under section 376/511 IPC. This court, under its order dated in notice and stay.
This on 16/11.
Notice dated 1/9/2022. While this court, under its order dated 1/9/2022, suspended the further proceeding of PRC case number 190/2022. This court had also called for the scan copies of the proceeding as well as the case diary. Full stop. Same is produced. Full stop. Peruse the same. In the FIR, it is alleged. Where is the FIR? In the petition?
Page number 20.
In the FIR, it is alleged that
Page number 18 is done,
got 3 is not it?
my lordship.
Alleged that under the leadership of accused number 1, the present petitioner is named as accused number 3 in the substitute. It is alleged in the FIR that on 6/12/2018 at around 7 p.m. under the leadership of accused number 1, the accused number 2 and 3,
The accused number 1 had committed rape upon me.
accused number 2 and 3 kidnapped her from her residence.
Leadership of accused number 2 and 3, my lord. Accused number 1 had committed.
Okay, in the leadership of accused number 2 and 3, accused number 1 kidnapped her, and accused number 1 raped her near Patiri village, near the road of Patiri village. And thereafter, the village people raised her after hearing her hue cry. During the course of investigation, the prosecution recorded her statement under section 161 CRPC as well as under section 164 CRPC. In her statement recorded before the magistrate under section 164, she had stated that on 6/12/2018 around 7 p.m. she eloped with accused number 1.
My lord.
Accused number 1. And while they were going, they found the accused number 2 and 3. And then the accused number 1 paid away, leaving her there. And thereafter, the present petitioner, that is accused number 3, that's her mobile, and then she raised hue and cry, and then the nearby villagers reached the place. The accused number 3 also tried to go away, leaving her there. However, when the the villagers came, the villagers came. Your name was
Uthal Pego, my lord.
this came. The accused number 3 dropped her in the place of what is the name of the accused number 2? Nomal.
Denny Pegu.
Lady Pego, my lord.
And who is Nomal Pegu?
All, my lord.
Dropped her in the residence of one Nomal Pegu. And thereafter, her mobile was also returned back. But she said that you tried to rape her.
$161, my lord, come first, my lord.
And, but can
Then,
we
my
decide,
lord,
can we determine all this at this stage?
Because, my lord, all the other witnesses, my lord. All the witnesses taken together, my lord. There is not a whisper that this
So
particular.
the victim victim statement was also in her statement under section 161. Where is that 161? Her statement under 161. Okay. She stated that she was having a love affair with the accused number 1 since last 3 months. And he tried to kidnap her in a bike. While going, they met the accused number 3/present petitioner. Again, you tried to rape her.
One, my lord.
Huh?
One.
Tiniyojon. We do not know. These are the facts. These statements are there. We cannot say that this is absolutely contradictory.
Because, my lord.
The attempt to rape, she is consistent in all statements.
Yes, accused number 1, my lord.
No, all 3.
But 376, my lord. This is a case.
That we understand. But is it a stage? You are a seasoned criminal lawyer. We are exercising our power under 482.
My lord.
These are the statements before us.
This is why, my lord, there are other judgments of the Honorable Apex Court. All the informant.
Oh no, that we understand. But this is it is a stage. What is the stage?
That is why I have come under quashment of, my lord, because
we will have to treat is that because search sheet has already been filed. It's kind of a framing of search, kind of cognizance is taken.
Cognizance is taken.
Cognizance is taken on the material available on record. Investigation is complete. Now, what should be the standard of quashment? It cannot be a mini trial.
My lord.
What should the standard of quashment?
How, whether.
Tell us first that.
My lord.
These are the facts. In 3 statements, she has specifically stated. She may be correct, she may not be correct. 3 statements, she said that these 3 attempted to rape me. She candidly says that I had a relation with this boy, traveled together, we reached such and such. This is the constant. Reached such and plus space, these 3 persons tried to rape me. Whether raped or not raped, that is a different. Tried to rape me, then villagers came and I was rescued. This remains. There are some contradictions here and there. That can be subject matter of cross-examination.
My lordship, I agree, my lord.
Now, what should be the standard? Standard should be that even if we read, there should not be even any suspicion.
So now, my lord, that is why I am submitting, my lord. 3 persons were named. Basic allegations entirely against this Priyanath Pegu, who is the accused number 1.
No, rather Priyanath, she is supporting that he took me. I had a love affairs. He has kidnapped me. I did not want to go, but he said, "No, you sit in my bike," and then.
Because, my lord, one of the witnesses.
We understand. There may be, you may are not believable stories.
My lord, that is not my submission, my lord. 3 numbers of persons have been named as an accused person in the FIR. the main allegation is against one Priyanath Pegu, my lord, who happens to be her, my lord, boyfriend. Earlier, my lord, one of the statement I have seen, she is married and had a kid, my lord. Then, my lord, she eloped with this Priyanath Pegu, my lord, and in the way, my lord, the Priyanath Pegu and my lord, the alleged victim girl, they met me, my lord, on the road.
You and another.
Me and Denny Pegu, my lord. Now, my lord, Denny Pegu and Priyanath Pegu, they eloped, my lord. And I was there. Then villagers asked me to take her, my lord. That is how I took her, my lord. After conducting.
These are your defense.
No, my lord, that is the matter of record, my lord. On the basis
Matter of
the
record,
record,
says,
my lord,
I
am
have read
submitting.
it. I was allowing your petition, but while dictating, I could find that in one, I missed it. 164 say that
164.
your কঁঠাল পেগুৱে মোক বেয়া কাম কৰিব চেষ্টা কৰিছিল যদিও কৰিব নোৱাৰিলে বেয়া কাম মানে বলাৎকাৰ কৰিব বিচাৰিছিল. This is the statement in 164. Now come to 161. তিনিও উক্ত স্থানত তিনিওজনে মোক ধৰ্ষণ কৰিবলৈ চেষ্টা কৰি মোৰ লগত বেয়া ব্যৱহাৰ কৰাত. Okay. Now in the FIR also তিনিওজনে.
Now, my lord, the charge sheet altogether telling a different story, my lord. The two persons have not been named, my lord. Entire thing, my lord, has been put to me that I have done this, my lord.
They may be brought in by under 319.
319. But on
because
record,
they
my
are
lord,
not named, then we'll issue a notice to them why you are not been made parties.
so, my lord, their statements are there in the record. They must have been made a prosecution witness. Another three independent witness for a moment, my lordship may kindly see. Independent
You can
witnesses.
see everything, but tell us the standard.
Standard, my lord.
Standard to quash after completion of investigation, filing of charge sheet.
26, my lord. The language is clear, my lord. 376, my lord. In this particular case, 511, for a moment, argument's sake, my lord, I am not. 76, my lord. Yes, my lord.
What is the crime for attempt? What is the offense under attempt?
Offense, so whatever the punishment is there for 376, my lord.
Any special offense? The rape is 376. What should be the offense for attempt to rape?
Yes, my lord.
Now, my
Yes,
lord.
Mr. Das, what is the offense for
It has
attempt
been,
to
my
rape?
lord, categorized in different numbers, my lord. But in this particular case, my lord, our case, my lord, 376. Rape
Tell us
375, my
huh?
lord. 375, my lord. A man is said to commit rape if he penetrates
No,
his
that we
penis.
understand.
My lord.
There is no rape here. There is an attempt to rape.
Attempt.
My lord.
What is the offense for attempt to rape?
One half of the, my lord. And if, my lord, that
We are
attempt.
not saying about sentence.
Right.
Is there
Well,
any
if that
specific
attempt-
offense for attempt to rape and rape?
If that attempt could not have been prevented, definitely, my lord.
For my knowledge.
Yes.
An offense 376 is a rape, penetration and all. Suppose there is an attempt. What is the offense then? Sentence we understand. But what is the offense for attempting?
Yes, my lord. 511 of the, my lord, IPC that there is specifically for a punishment for attempting to commit offenses.
511. So
11.
that's why 376 with 511.
11, my lord.
So, my lord, in this particular case, because my
There
lord,
is no rape.
records
That's
have
why
been
511 is.
records have been called for, my lord. When, my lord, remotely also the records does not point out the commission of this particular offense, my lord. Only, my lord, this matter has been developed.
There is an attempt. No, there may be developed. You'll put into her that you have stated so and so. This is a major contradiction. This is a minor contradiction. That's why I am asking you.
My lord, why I have come, my lord?
You have come for quashing. According to you, this is a false case.
My lord,
This is a
161,
false case.
she has not stated also that, my lord, while putting her in Puthal Pegu's house, my lord, was, my lord, attempted by the present accused person, my lord. Specific, my lord.
You will have to make a better argument to What's this?
Now from the, my lord, whatever your lord.
You'll have to argue a better way.
My lord.
Saying facts,
Because so far as, my lord, the present case is concerned, my argument is limited to the extent, my lord, that particular case is a malicious proceeding because, my lord, 3 numbers of accused persons were named. Categorically, number 1 accused person was entirely, my lord, he had done all these things. Both of them eloped, my lord. In the middle of the road, she was left, my lord. She raised hue and cry, then, my lord. They were about to marry, my lord, but nothing materialized. That is why they abandoned, accused number 1 abandoned her.
they're facts.
These are facts, my lord.
They're facts.
Actually, I was submitting, my lord,
On the
altogether,
basis of facts,
my lord.
where in 3 stages she has said she may be wrong statements, and if the whole of the other witnesses, now we see that you 4 persons were in a place of there was hue and cry. Whether it is for the mobile or whether this is for some other reason,
There is, my lord, huge.
but the witness says statements there is an attempt.
No, my lord. FIR, clear allegation of rape in the roadside, my lord.
That we understand. Here allegation of rape, here there is a contradiction. Contradiction, if it is a material contradiction and this not trustworthy, then of course acquittal.
Only on the basis of
But the
her
standard of
statement, my lord.
482 should be, no, should not be there should not be any even suspicion. Isn't it?
Yes, my lord.
If
That
that
is
is so,
correct.
there is a suspicion.
Because, my lord, absolutely, my lord, this is not a case of, my submission is not on the basis of suspicion. My case is, I'm relying wholly on the basis of the else available before your lordship, my lord.
The material
The-
available on record should satisfy this court that
whether-
if we take everything to be correct, there is no there is even no suspicion
And-
that you have.
And whether, my lord, it will be an abuse of the process of the court if this particular
Abuse
case
will
is
again
allowed
depend upon
to be proceed, my lord.
abuse will again, then we'll have to come to the merit of her statement.
My lord.
We'll have to come that her statements are not unbelievable. She is having contradiction. These are subject matter of trial.
Allegation that has been made in the FIR, my lord, categorically against, only against. this
Understand?
everyone.
You say
That is
that
the
there is an
number one
allegation
point.
of rape in the FIR. In 161, there is an attempt to rape. In 164, there is an attempt to rape. And
Medical is not supporting.
medical
Other
is not
witnesses,
supporting.
there is no
This
whisper about.
can this be, can record all these things to quash a 370.
There are judgments of Honorable Apex Court. If lordship permits me, my lord, I'll come, my lord.
I
Only
myself is
prayer-
having a doubt.
my lord.
Then it will be
I
a mini
understand.
trial. Doing mini
understand.
trial, taking determination on the basis of the, if you
May I-
can satisfy, of
May I
course.
pray only one aspect, my lord? May
When
I
is
be
the next
allowed,
date?
my lord, the
When is the next date?
26 July. In the meantime, may I be allowed, my lord, the copies of 161 statements so that I can satisfy your lordship with regard to my lord?
Go through it. This is
Zero-
here.
Yes, my lord, I have.
Go through it. There's a scanned copies. Go through it. Here, go through it. Bothagurs are doing like.
Otherwise, my lord, your lordship has rightly pointed out, my lord, regarding in one.
See, we can pass an order. That is not a problem. We might have mental satisfaction that is this is an order, but we want a legal standard so that we can rely on that this is the legal standard and this case fits into that legal standard.
My lordship.
Pass orders on our
factual-
satisfaction.
There is 2013 3 assist
Pass those
judgment, my
judgment.
lord.
What I can mind with my limited knowledge, I understand is cognizance is taken or even argument under discharge under 227 or something is done. Standard should be that on the face of the material, then there is no suspicion.
My lord.
This is the standard at that stage.
The judgment, my lord, which I am referring, my lord, that Honorable Apex Court has decided the defense plea, my lord. That, my lord, without going into, my lord, because that is.
Anyway, we'll hear if on the first learned counsel for
On first week of June, my lord.
Xerox
copy.
Xerox is difficult to.
Side 161, I won't get my.
Go through it here. Take down. 10-15 minutes.
I'll take it down.
Go through and take the.
My lord,
11, sir.
interim may kindly be continued. Till then, interim may be continued.
Interim order pass earlier shall continue till.
Deeply obliged.
Just satisfy us.
I'll satisfy me.
On
I'll
this
come
basis of this
on fact,
statement,
my lord.
on basis of this statement, this is the proposition of law.
My lord.
This court can,
And on the fact.
because we cannot go to the stories. What is before us on the basis of that.
On the factual aspect, whether honorable court can come to a logical conclusion that yes, this can be quashed or not. Deeply obliged.
We'll see the whatever on record.
My
If
lord.
that basis, legal principle permits quashment, and we have said in 3 statements he has attempt to rape.
Yes, my lord.
That this statement can also be negated and quashed on the basis of the statement of the other witnesses. Then I think this will be a mini trial. Determining on the merit.
One of the judgment, I'll place it, my lord, on our next. Deeply obliged.
Maybe my limited knowledge, but
2013
my
itself, my
knowledge.
lord, that proposition has been.
yes, next.
Deeply obliged, my lord.
Don't be in 2013 also. There are 23,
23, my lord.
24 judgments. Respondents. no? Appears for the none appears for the partisan call. Accordingly, in the interest of justice, matter stands adjourned. Order passed earlier on 8/7/2022 stands vacated.
May I please, Lordship? Lordship, to approachment of the PRC case, my lord. My lord, in this case, the petitioner and the informant's wife contested one panchayat election, my lord. Wherein, for contesting panchayat election, my lord, my minimum qualification was HSLC passed or equivalent exam passed, my lord. This petitioner produced one Praveshika pass from Sanskrit 12, my lord. The informant, after winning this petition, after winning this election, my lord, the informant filed an FIR stating that the certificate I have produced that was fraudulent, my lord. This is the case, my lord.
Now the report says yes, there is no certificate.
My lord.
The report from the
Wait and then.
author of the certificate, purported author of the certificate, that there is no such certificate.
That student also.
No such student. Why should he quash?
My lord, I have passed the exam, my lord. The college, the school authority issued the provisional certificate, my lord. Thereafter,
So they
I
say
have,
this is fraud. We have
my lord, the very question that is the fraudulent certificate that has been posted, came by post, my lord, registered post, my
we
lord.
do not know. Can that be ground of quashing? Tell us that. You satisfy us that whatever I have said is correct and whatever prosecution said is incorrect, therefore quash it.
The last occasion Lordship's query was that after seizing the document, my lord, that is the certificate, whether the IO has been, IO has sent for forensics test or that not, my lord.
That is for the interest of thing, but
Otherwise, I have mark sheet that these documents have been seized by the IO, my lord. Mark sheet, registration certificate, then
all seized, all
My lord,
seized, it was
all
sent,
seized.
all seized, it was sent
Then-
to the, where is that?
That report has been given by the registrar and he is listed as PW5.
Everything is there, why should you quash it? Your whole ground is that this is a Melafied FIR.
Yes, my lord.
Melafied is fair because she lost the election. This
Lost
is
it.
your case.
Lost it.
But
And I have
maybe Melafide, but ultimately it happened that she was correct.
Because,
If
my
she's
lord,
correct, she may not be correct. That is be taken by the trial.
No, my lord. This is the documentary evidence, my lord. And I have produced all these documents. And
Okay, so we'll have to decide that these documents are correct or these are not.
No, my lord. That has to be
But
investigated.
every time you are saying no. I am putting a question.
my lord.
You have said certain things, bought some documents. You have said that I do not know. It has come by post. This is
No.
my case. Okay.
After passing, my lord.
After passing, I appeared. After passing, this
Yes.
certificate came by post. This is my certificate. I have applied it. Fine. Now the author, who according to have sent to you, said that no, there is no such student. And he is listed as witness. Now you want quashment. Now say us the what is the quash under what provision will quash? Last tell us.
My lord, the provisional certificate issued by the Pradhan Adhyapika, my lord.
They're facts.
No, but this is the certificate. This is on record, my lord.
This certificate they have disowned. Problem is this. If they would have said that yes, this is a certificate we have issued, we would have quashed this right now because this is an admitted documents or facts on the basis of which even documents we can rely on when it is admitted. The document is not admitted, what to do?
Whether this provision, this headmaster was interrogated or not, that is not in. Then the board's mark sheet, my lord. Then the board has
So
issued the
therefore, these
certificate.
are the investigation, these are the matters of trial. We cannot go.
My lord, whether these are based on documents, my lord. And if these documents have been sent for FSL, my lord, if it is proved that these documents are genuine, my lord, then the case will not.
Now you want that? Let the report from forensic come and you take a conclusion that this is forensic is correct or not correct.
And this is the issue by the FIR, my lord. The document is fraud, my lord.
And arguing what should be argued. You are facts, you are like we are treated like trial courts. Is 161 statements are materials are treated as evidence.
My lord,
Isn't it?
most of the evidences are, my lord, they are petition, my lord.
These are not evidences, these are materials.
Materials, my lord,
This
that
will become evidence
Witnesses
later
are
on.
how this private person, my lord, that Inamul Haq, who is the informant, my lord, who is my neighbor, how he will know that I have passed or not, my lord. Then his brother and other individuals, my lord.
He has also explained. Problem is this. He said that this boy has never gone to school. He was doing so and so.
That cannot be, my lord.
You do not know.
Whether I have appeared in the exam, I have passed the exam, I have passed the exam or not, how they can know, my lord.
So your statements are gospel truth. Therefore, the prosecution has committed a serious mistake proceeding against you. Therefore, let it be quashed. Isn't it? Whatever you are saying is correct and whatever investigation made is wrong. So under 482, let us quash this.
But my simple query is that whether the issuing authority, my lord, that is the Pradhan Adhyapika, whether he has been examined, my lord.
You do not know.
If
And we are not concerned.
If he or she is not examined, my lord.
Case is made out, a charge sheet is filed.
Whether these documents, which the documents, my lord, these are on record, my lord. And whether these documents have been sent for FSL, my lord. For proving whether
Original school documents seized from the school.
Yes, my lord. And on the last occasion on 7/9/2023, lordship has made this query, my lord.
In all the documents, his roll number, that roll number has been specifically mentioned in the report also, Lordship, as being not found.
And that register, my lord, in his report, he has stated that he has lost he doesn't have the records now, my lord.
Where is that? Some report is there. I have seen. Where it has gone?
Take mark, Lordship.
Huh? The
Take mark.
certificate, no record. This is. Register Kumar Bhaskar Burma Sanskrit. This. Art.
Lord, last line of that report, my lord, kindly, last line, my lord. He has specifically stated that he doesn't have the record. He doesn't have the records, my lord. How he can say, my lord?
Therefore, there is no record of issuance of
My lord,
certificate.
on flood, my lord, he has stated that not he only this petitioner's record, my lord. In a flood, my lord, he has lost the entire record, my lord.
Heard, Mr. Mr.
Chanda, my lord.
The B. Sharma lot. Public estate and Mr. Ahmed for the present application is filed. Section 482 for quashing and setting aside charge sheet number 30 of 2 filed in connection with Kaki PS case number 7 corresponding to PRC case number 1288/2019. FIR was lodged by the respondent number 2, Sir Elia, alleging that is the FIR.
My lord, FIR copy, I did not annex, my lord. I did not find it, my lord. It is on record, my lord. I have seen.
The FIR is at space 14, lordship.
Of
It is in the format, my lord. The content of the FIR I could not receive, my lord.
But also, my lord, the
Yes,
my lord, lord's FIR. Authority lodged FIR, lordship.
what is the FIR?
No, my lord.
Verified.
It doesn't have
It's in the LCR, Lordship. Here the FIR, there, Lordship. Otherwise, it's dated 19/3/2011.
Informant is Ainul Haq, my lord.
FIR. Sir Elia alleging that the present petitioner / accused had submitted a forged certificate relating to his matriculation that his qualification matriculation qualification is was declared on the basis of a force certificate issued by the what is the board? Assam Sanskrit Board, Kahilipara, Guwahati. On the basis of the aforesaid FIR, the connected police station case was registered. Police station case number so and so was registered, and investigation was started. During the course of the investigation, the investigating officer recorded the statements of witnesses and also seized certain documents including one original school Pravesika examination pass verification report of the petitioner from the headmaster Lakhikanta Sinha from the school, from the headmaster of the school, where according to the petitioner, which school the petitioner studied, according to the petitioner. Original certificate of the petitioner issued by the Assam Sanskrit Board has also, including the mark sheet, has also been produced, has also been seized. And statements of the statement of the authorities had also been recorded. On the basis of aforesaid, the search sheet was filed, and accordingly, the court under the learned trial court under its order dated cognizance on order dated 18th of April 2022 charges against the petitioner under section 468 plus 471 section 465 IPC. From the material available and record, the learned trial court had a prima facie satisfaction against commission of the offences as discussed herein above. It is by now well settled that at the stage of framing charges, the court has to consider the material only with a view to find out if there is any ground for presuming that accused had committed the offence. The case in hand, from the materials available on the case diary, including the seized documents, if are taken to be correct on its face value, discloses existence of the ingredients of the offences alleged to have been committed. Though the learned counsel for the petitioner has urged that this is a malicious prosecution inasmuch as the respondent number 2 and the petitioner contested for Panchayat election, wherein the present petitioner was successful. defeating the respondent number 2. However, respondent number 2's wife. However, the sin cannot be ground for quashment of the entire proceeding by appreciating and oblique or appreciating the statements made by the witnesses and the documents seized by the investigating authorities. This court, in exercise of power under section 482 CRPC, cannot consider the allegations on merit and cannot make an inquiry to find out on the basis of the materials collected and can make a conclusion that on the basis of material collected against the petitioner, collected against the accused is likely to be convicted or not. When there are suspicion, grave suspicion in such a grave suspicion from the available materials on record, then also this court cannot proceed to discharge a person in exercise of its power under section 4. While considering such discharge, this court cannot do a mini trial and only to look into the materials available on record and to consider that even if it is taken on its face value and are treated to be correct, there will be no suspicion that the petitioner, that accused has committed a mistake, committed the offense, full stop, which is not the case in the present case. Accordingly, the present petition stands dismissed, being devoid of merit. Interim order passed earlier, if any, stands vacated.
Obliged, madam.
Yes, what is this?
Appearing for respondent number 2, Lordship. I have filed one IA Lordship, seeking for interim maintenance Lordship and also cost of the proceeding Lordship. Since the petitioner Lordship order has been passed before the lower court Lordship, he has evaded from paying maintenance Lordship.
Now you are for the response.
Yes, Lordship.
What
Respondent
is
number
the
2,
what is the challenge here?
Lordship, in this petition, Lordship have challenged an impute order passed by the principal Judge Family Court Silchar, Lordship.
Where is that?
Order is on Annexure 7, page 38, Lordship.
Yes.
38, Lordship.
Yes, now.
Lordship, the petitioner is working in a private school, Lordship. So he does not have that provide maintenance of Lordship around 10,000 rupees, Lordship. So that is the reasons why we have filed that petition, Lordship, to challenge this order. Now the council on the other side today filed an IA, Lordship. So
now are you paying this amount?
Lordship, nowadays.
Tell us that there is no stay order.
Yes, Lordship.
Are you paying this amount?
So, Lordship, for that I need to take instructions, Lordship. I am not having contact with him for the last.
We'll dismiss then. Dismiss this petition. All revision. Nothing is there.
Only twice, Lordship, they have paid.
We cannot proceed.
Yes,
determine all
Lordship.
these factual.
And this is a social justice act, Lordship. These things are.
Lordship may take it Next week, Lordship, because conduct.
Day after tomorrow,
Yes, Lordship. Lordship.
Thursday.
Obliged, Lordship.
Thursday, learned counsel for the respondent has filed an IA. Registered as IA main case IA criminal 490 of 2024. The learned counsel for the petitioner seeks an accommodation to go through and argue the matter on Thursday. Prayer is allowed. List this matter on.
Obliged, Lordship.
Deeply obliged, your Lordship.
Will examine your matter, provided you can come and say that we are paying. Yes, item number?
Petition for quashing of an act case.
Why?
We have already paid the amount. As per the-
My lord. He says, he has come before this honorable corner 482.
No, that will come. He has made a statement that he has paid.
He has paid.
Okay.
Now, my lord, this NI Act was filed when check bounce has taken place. After going to the procedural law, issuing notice, legal notice, did not pay. After that filing of the notice, in the meantime, it has come to the WhatsApp that money has been paid. But ledger amount was also side by side maintained. And which amount has been paid, that is not been clarified by the him, my lord. That is only a legal
Your
point.
Lordship, they have filed a reply kindly in paragraph 5. Of the reply.
Paragraph 5, where is the reply? Reply is not here.
My reply means affidavit in opposition. Paragraph 5. Yes.
It is not here. Submitted by the learned counsel. And reply affidavit has been filed by the respondent number 1.
3.
Respondent number 3.
Representative
Name is not on record, registry to verify and connect the same with the record and list this matter on Friday next.
Friday next month. It highly obliged.
Be happy with whatever you have got.
With all respect, my lord. With all respect, my lord.
Protective application, my lord, earlier. And something completed, I think, my lord.
Give us some time to file affidavit in opposition, Lordship.
What you want? You are quashing of?
Trial proceeding.
Trial proceeding CR, GR?
PRC, my lord. PRC 2547, 19, my lord. My lord, page number 45, my lord. Or 45, my lord.
Learned counsel for the respondent has entered appearance and submits that she may be granted some appearance on behalf of respondent number 2. Number 2 entered appearance and 6 a week's time to the petition.
My lord, maybe continue.
Is allowed. Is this matter after 2 pass earlier, shall continue.
Obliged.
Yes, what about the other side?
They have taken steps upon them due.
You have today taken steps today. Learned counsel for the petitioner submits that steps for issuance of notice upon response taken today only. Accordingly, submits that matter may be adjourned. Prayer is allowed. Please this matter after 4 weeks. With no interim is there.
Last occasion,
Interim
Court
period of
direct-
petition shall be considered after receiving record from the learned court below on the next returnable date. There is no interim. And you have not taken steps thinking that there is an interim.
In this case, my lord, twice we have earlier give signal to the my lord, concerned OC, my lord, whether case is pending. Today itself, my lord, over telephone, but till now he has not given any instruction, my lord. OC Borpeta PS.
Heard. The
And Ahmed.
and Ahmed Learned Counsel. Also heard Mr. Parasar. Hearing on behalf of applicant, namely so and so, has approached this court filing the present petition under authority to CRPC for granting him free arrest bail. The case of the applicant is that though no case has been registered against the present applicant any police station, but he is being charged by the Borpeta police personnel from Borpeta police station, and the applicant apprehends that in the event of his appearance at the police station, he may be arrested. Since no FIR has been registered against the present applicant, this court sought for instruction from the learned additional public prosecutor and to obtain a written report from the officer in charge, Borpeta police station, as to whether any FIR has been lodged by any person against the present petitioner. Fixing the, so accordingly, full stop. According the matter was fixed on 17/5/2024. On 17/5/2024, the BB Gogoi Learned Additional Public Prosecutor submitted that he has not received the instruction as prayed for, and therefore an adjournment was sought. Full stop. Accordingly, prayer was allowed and the matter was directed to be listed today. Directive listed on 20/05/2024.
On 20/05, it is.
When matter was again listed on 20/05/2024, Mr. Parasar, learned additional public prosecutor, once again sought time to obtain the instruction. Full stop. Such prayer was allowed and the matter was directed to be listed today. Full stop. Today. When the matter was called in the first part of the day, Mr. Parasar sought for an adjournment.
Two signal 9/5 and 25.
Sought sent for an adjournment. And for an adjournment for time being, so as to enable him to obtain the instruction from the IO. Accordingly, matter is now called after the entire list was over at 4:30 p.m. Mr. Parasar submits that he has intimated the OC Borpeta police station seeking
From our office, madam. From our office, madam.
Full stop. It is submitted by Mr. Parasar, learned additional public prosecutor, that the office of the public prosecutor intimated the IO as regards the order seeking instruction on
9/5 and 25.
On 9/5/2024 and
20,
again on 20/05/2024. However, when no such instruction was given, Mr. Parasar has once again tried to telephonically inform them, and thereafter also no instruction has been received till. In view of the aforesaid, let the officer in charge, Borpeta police station, remain personally present before this court on Friday next at 10:15 a.m. 31st at 10:15 p.m. No coercive action shall be taken against the petitioner in connection with any case that has been registered for Borpeta police station case.
Eight, my lord, one instruction is they don't not written. In Panbazar PS, they don't have. But in women, Panbazar women, Malat, maybe Malat, it is also Malat, not.
Okay, we are fixing this matter.
After tomorrow, Malat, or
Day after
with
tomorrow.
with
The problem is this, I'm supposed. Comment officer lordship.
Okay.
Comment servant lordship.
Sir, you are
Dr.
Mr.
PP Methi lordship.
Huh? You are Mr.
Dr. PP Methi.
Present application under section 438 of the Code of Criminal Procedure 1973 filed praying for pre-arrest bail with an pre-bail with the background fact that the ACP within bracket Women Unit, Panbazar Police Commissioner at Guwahati had issued a notice to the petitioner to appear before the state officer on 28/5/2024 at 11 AM for recording of statement in connection with a complaint submitted by his wife, Srimati Mousumi Das. The ACP has not disclosed regarding registration of any complaint in as much as, according to Mr. Parasar, it might be an inquiry also before registration. Full stop. Sir, Medhi, learned counsel referring to certain documents stating the certain documents disclosing case history between the petitioner and his wife arising out of matrimonial discord. Full stop. Considering the matter in entirety and considering that the dispute relates to family discord between husband and wife, it is provided that the petitioner's no coercive action shall be taken against the petitioner in connection with the complaint purportedly filed by the wife of the petitioner as disclosed in the notice dated 18/5/2024 issued by ACP within bracket Women Unit Panbazar. Full stop. List this matter on motion column on Wednesday. The appearance of the petitioner before the IO, before the said officer in terms of the notice dated 18/5/2024 dispense with for the time being.
I'm deeply obliged, lordship.
They're trying, but
No, no, it's all right, it's all right, it's all right. I have seen since morning, my lord.
yes, go. Well,
Excise, my lord, excise. Not possible.
No, my one is 11, his one is 11.
you are for 11.
11.
About 11. Oh, sorry, my lord.
Item 11, can it be fixed on 19th of June, Lord?
And what is your matter, Mr.?
Want to raise that hearing matter, madam. So can it come on Thursday on 30th?
Inside
There is
jail?
some urgency, madam.
Urgency?
Because he's appointed already, but this man is not.
He's
joined in his service, man. So although his appointment is. He has been convicted under section 14 of the Gambling Act, my lord.
We're trying our level base what to do.
What attempt may be made, if possible, on 30th, man.
Okay, your is on Thursday. And what about Mr. Gogoi?
19th, Lord.
19th.
of
Okay.
June.
No, don't take it on motion day.
On the next week, Lordship, he will appear through virtually, Lordship.
Arshwell is the, in fact, we have heard him, only we'll have to hear him that basic fundamental issue is that it is, if it is an excisable, it is excisable. This is the
Yes.
argument that we want to, that's all.
That we can address on
Other, his
20.
whole case is that this is the procedure follows, I am not entitled. Your whole case is that when it is matter is an exercisable, it is to be exercisable, it is to be paid.
Once it comes out of the factory, you have to pay.
Okay.
That's a minute and 20, it can fix minutes, just a limited.
Next week, Lordship, then any date.
Any date minutes.
We are fixing it on 19th, let us see.
Pilots.
Possible, otherwise 19th.
Pilots.
And what about Mr. Your case is, Hazarika's case is on Thursday. Yours is on 19th and Mr. March 6th. We'll online it, 2N.
When it motion method.
We'll do it right now. We'll do it.